Just look at the affidavit.
Give a proper officer first. The materials placed for this court therefore indicate that the officers concerned have been appointed on notifications issued and exercise statutory powers under Section 3 and 5 CGST Act. Further notification circulars relied upon by respondents had demonstrated that officers of DGGI, as well as additional commissioners, have been assigned functions relating to issuance and adjudication of proceedings under Section 73 of the Act. At this stage, the court is not persuaded that the challenge raised demonstrates an inherent lack of jurisdiction or absence of jurisdictional facts within the root of the matter. Mere disagreement regarding interpretation or scope of powers conferred under statutory notifications cannot by itself convert an issue into jurisdictional defect warranting interference on Article 226. This court also observes that merely because a challenge to notification circulars has been couched in constitutional terms does not automatically confer maintainability. The substantive dispute pertains to tax assessment and classification. Courts are required to examine the true nature of controversy and not merely the form in which reliefs have been drafted. On a careful consideration of pleadings, it is evident that central controversy between the parties concerns classification of services under SEC 9954, SEC 9967, applicability of exemption under entry 23A of notification number 12 2017, characterization of annuity receipts under BOT projects, and taxability of composite supplies under CGST framework. Though on a plain analysis by virtue of entry 23, the petitioner would be liable for paying GST on annuity. The other questions that remain, however, would involve interpretation of contractual clauses, examination of nature of services rendered under the concession agreement, determination of principal supply, applicability of exemption notifications, and application of factual as well as legal aspects. Such questions, the current opinion of this court, cannot be regarded as pure questions of law capable of adjudication in writ proceedings in the first instance. The contention of petitioner of the issue stands concluded by a judgment rendered by Karnataka High Court in the matter relating to DPJ Bidar also cannot persuade this court to entertain the petition. The respondents have pointed out that proceedings arising therefrom are stated to be pending consideration to any event legal position itself has not attained finality. This court also notices that the petitioner had participated in education proceedings pursuant to direction of the Honorable Supreme Court, submitted replies, appeared during personal hearing, and advanced detailed submissions before the adjudicating authority. The order originally records consideration of such submissions and ultimately arrives at conclusion merits. Whether the findings recorded therein are correct or erroneous is a matter falling squarely within the appellate mechanism contemplated under the statute. The petitioner further argued the auto remedy available in the CGST Act is inefficacious because authorities under the statute would be bound by circulars issued under Section 168 of the Act. This argument also cannot be accepted. Mere existence of binding circulars does not render the statutory appellate mechanism onerous or ineffective. And though remedy may not be as efficacious as the writ petition, auto remedy, however, is in the present case handy and accessible. Moreover, though orders of instructions issued by the board is not law, it may be binding upon authorities, but not appellate authority, who is not bound to take judicial note of such order instruction. The instant case is not a case of palpable injustice being caused to force SSC to adopt the remedy, as much as appellate authority under the Act possesses powers to examine questions arising in the adjudication order, and thereafter statutory remedies extending up to judicial forums also available. Having considered the entirety of the facts circumstances and taking the account of authorities placed by the petitioner, this court of considered view that none of the recognized exceptions to the rule of auto remedy have been made up to the petitioner. No violation of principles of natural justice has been demonstrated. No patent lack of jurisdiction has been established. The challenge raised by the petitioner substantially pertains to adjudicatory findings and interpretation of statutory provisions and exemption notifications which are amenable to examination before the appellate authority under the CGST Act. Consequently, the court declines to exercise jurisdiction under Article 226. However, considering the fact that the petitioner has pursued proceedings for this court bona fide, liberty is granted the petitioner to avail statutory remedy of appeal under Section 107 of the CJSC Act within a period of 4 weeks from today. In the event such appeal is preferred within the approval period, the authority shall consider the same on merits and in accordance with law without being influenced by any observations made in the judgment.
Any mention?
Please, Your Lordship. Sir, to make a mention of item 7, Your Lordship.
Number
7, Your Lordship.
7.
7, Your Lordship. Lordship, we are supposed to file a written argument. Lordship, I pay on Thursday, Your Lordship.
Which one is this?
That the various of the act. Yes, Your Lordship. Thursday, Your Lordship.
You'll find Thursday.
Ours is ready, Lordship.
You find it together Thursday. Yes, Mr. B. Kiriam.
Askriam, Your Lordship.
Askriam, sorry. Please that you allowed 2 days time to submit the notes on written submission. It is allowed. Just the matter on Thursday of submission notes of written submissions.
Obliged.
Supplementary list, item number 2.
Yes,
May it please your Lordship.
Dr. P. Agarwal.
Lordship, this is an restoration application. Your Lordship had dismissed the income tax appeal due to non-prosecution by order dated 23/4/2026.
How many times didn't appear?
Lordship, not me. It was the previous conductor.
You whatever is at the office.
Lordship, the office was not aware about the dismissal also. In fact, on 15th of May, when this matter was endorsed to me for pursuing before this honorable court, and I checked on e-court services what is the next date, then we came to know that the matter has already been dismissed, and we have filed.
Where's MSR Kolni? They accept notice. You have to issue notice.
Lordship.
This take down this case also. There's an application for restoration of income tax appeal number 1/2024, which was dismissed on 23/4/2026. That notice issue. Steps to be taken within
3 days, Lordship.
within 3 days. Yes. Yes. After 2 weeks.
Obliged, Lordship.
Item number 3.
Lordship, item number 3 is the same. The only thing is ITA number will be 2 of 2025.
Income tax appeal number 2.
Obliged, Lordship.
Daily list, item number 1.
May it please your
You
Lordship.
corrected the cost title?
Yes, ma'am, I have done, my Lord.
What is the matter?
My Lord, I am challenging my Lord, form DRC 01 that your Lordship will find at page 27, my Lord, pursuant to which the impugn order has been passed.
Which page?
Page, my Lord, 27. My Lord, this is a summary of so-called notice, my Lord. Actually, my section 7.
This notice written at
Yes, this is
Across?
Lordship will find this summary of so-called notice written there.
Where?
It is just, my Lord, below this
Annex D.
Annex D, my Lord, 27.
Is this the format of notice, Mr.
my
Sukal?
My lord, this is this is a so-called notice, my lord.
The format of notice. If it's
this
printed
is
like this, how will you read the
my lord.
content?
This is how it has been uploaded, my lord.
Then how will you read the contents then?
No, my Lord, actually there is no so-called notice as per section 73. They have uploaded only a summary of the so-called notice. The requirement of law is that, my Lord, they will issue a so-called notice under section 73(1), my Lord. Thereafter, my Lord, they will upload a summary of the so-called notice. Now, my Lord, I have relied upon a judgment on the earlier occasion of the Guwahati High Court.
Case that there were no so-called
There was no so-called, only summary was there, my Lord. A summary cannot substitute a so-called
And where's the
notice.
impugn order?
Lordship, that your Lordship will find it, my Lord, page 31.
Why do you have to do like this? I mean, order like this. You can't read. It's printed right across the.
My lord, I will communicate to the concerned officer.
You tell your authorities. I mean, it might be in order, but then it's in bold and it covers the entire print.
Right.
It's always like this.
Well, this is summary notice. Well, this is even in other cases also the issue like this.
So summary means this is the impugn order, right? Page 31.
Yes, my lord. Page 31.
You see for yourself.
Well,
We can understand a watermark, but not a black mark like this on top, right on top of the order.
I'll communicate, my lord.
I am relying upon the judge.
They actually, they have watermarks for this.
Yes.
What is the purport of this order?
I am relying upon this order was, it does not contain any reason, my lord. They simply put the figures, my lord, and they said to pay the amount, my lord.
Can't read order. Whoever doing in your office doesn't know what a watermark is. Mr. Singhal, kindly supply. Even operative part you can't read. My brother has shown you can't read in page 32. You have to pay payment by when? What's written here?
It was, my lord, 27/9/2025, my lord. Thereafter recovery was initiated. I am relying upon judgment of the Guwahati High Court. Last time I have relied. Well, the court has held, my lord, a summary of so-called notice cannot substitute, and my lord, the matter was remanded back for issuance of fresh so-called notice, my lord.
Let them file affidavit, and you please bring the legible copies.
My lord, I'll do that. My lord, first of all, my lord, this application, my lord, this is not maintainable in view of the fact that there is already an appellate authority, my lord. Under 107, my lord, appeal should lie before the appellate authority. So they have come before this court directly. And moreover,
They have come for violation of the principle of natural justice, that's all.
no, my lord, may kindly see 160 of Meghalaya Goods and
His
Services.
case is only that he has not been issued show cause, correct?
Yes, ma'am.
And the assessment order has been passed. That's
My
all.
lord, it was already given, my lord. This is the show cause notice that they have already enclosed. There is no my lord, I'll read out the provision of section 160, which says 160 clause 2, my lord. It says the service of any notice, order or communication shall not be called in question if the notice or order or communications, as the case may be, has already been acted upon by the person.
Then you file a short affidavit.
Yes, my lord.
I am praying for some protection, my lord.
My lord,
Mr. R. Mishra.
my lord, I have objections regarding that because this is not maintainable at all, my lord. They cannot come directly to the High Court.
R.S. Mishra,
R.S. Mishra, my lord.
counsel for the petitioner. Stop issue notice. Mr. Engson Khan, for all the respondents.
My,
All the respondents. Yes, Mr. Khan, the GA is present and accept notice on behalf of all the respondents. Such no further notice required. Stop. The writ petitioner, next paragraph. Counsel for the writ petitioner has submitted that. That the petitioner is a registered SSE under the provisions of the Meghalaya GST. And that he was served with a summary show cause notice dated
11/2024, my lord.
28/2024 by the respondent before, wherein a demand was raised for rupees how much?
19,90,088.
So the case of the petitioner is that no show cause notice was served prior to the issuance of the DRC-01 as required under section 73 of the CGST/MGST Act 17. So therefore he contends that as there has been a violation of principle of natural justice, he has been compelled to approach this court by way of this application under Article 226. He further prays that no course of action be taken against the petitioner during the pendency of the writ petition. Next by Ms. Ensign Con Leonard, GA for the respondent, has countered the submissions by submitting that the writ petition is itself not maintainable in view of the provision of appeal under Section 107 of the GST Act. Further, he submits that any summary show cause notice that has been acted upon cannot be questioned as further proceedings have emanated therefrom.
In view of
However,
section
prayers that
160.
we would allowed to put in a small affidavit on a question of maintainability of the writ petition. Stop. The prayers allowed. Affidavit we filed within
1 week time.
1 week.
Only on that maintainability issue.
Stop. Yes. The next, however, it's provided that till the next date, no course of action can be taken against the writ petitioners. This accordingly and so on. Sir.
Much obliged.
Item number 2.
Well, here we are required to file an affidavit to the miscase file for stay, my lord. It is in the process of filing. But here what happened, my lord? They have deposited certain, as per the directions of Lordship, my lord. They have deposited the money. We opened the website, my lord, for a certain period, and they were required to file returns. Now that they did not file returns, again it has been locked, my lord.
So, my lord,
Again
actually,
deregistered.
no, my lord, actually, portal was open, but whenever we open the filing, it is not accepting. The amount is showing that this amount is to be paid first, then only that will be filed. So we are unable to file. Again, that has been blocked. And now there is no scope to make any file, no any reply, any returns, nothing. So unless until this amount has been stayed, so nothing can be done, sir. Hello.
Your miscase, what's the
Yes,
prayer?
I have filed.
Miscase?
Miscase 4326, I have filed. And
But I'm just placing the instructions when I have received.
This case, have you filed affidavit?
We are filing affidavit, but the contents are here.
Filing today?
Yes, ma'am. We
In the
are
course of
filing
the day?
course of the day. But the
Let the file
instructions.
go through the day. We'll have it on Thursday.
yes,
You can examine
Thursday.
it at your leisure. Yes.
Yes, sir.
Yes, Dr. N. Mozikas submits that the affidavit objection to the application for stay of recovery
Yes,
will be filed in the course of the day. This is the matter on Thursday.
yes, well.
3.
Okay,
The pending thing.
May it please your lordship. Lordship, I have received the instructions just yesterday. I pray for 2 weeks' time to file affidavit.
Okay, Ms. Dr. P. Agarwal, Learned Counsel for the respondents, prays for and without further 3 weeks time to file affidavit. Yes.
Obliged, lordship.
4.
Well, we have taken steps, my lord. Mr. Manta's opinion.
I'm appearing for all the four.
Bitlan
It's a gold is.
for gold. Delay?
No, in fact, appellate authority has directed to release the money. It is not a
No,
gold
there's a
process.
delay.
There's a delay of 105 days.
Delay 105 days, I think.
You're not contesting.
Although it was not explained properly anyhow. It's okay for.
Yes, sir. Where's the miscase? Miscase Customs Appeal number 1 2026. And first time you're taking appearance today.
First time.
Yes, Mr. S.P. Mantana, Senior Counsel with Mr. Dundo, has entered appearance today on behalf of all the respondents.
All the respondents.
All the respondents. Such notice is complete on all respondents. After that, in this application, there's 105 days delay in filing the appeal against the CESTAT CST80 final order dated 2/7/2025, passed in Customs Appeal number 75381-75384 of 2021. Dr. M. Muzika has placed the application and submits that. What's your submission on delay?
Well, because it has to be examined at multiple levels. Well,
And
Government
that the
machinery.
delay of 105 days was caused to unavoidable reasons as the what has to go through, as the examination matter had to proceed to different levels. So he praised that the delay be condoned as the delay to condone stop. Mr. Samantha in reply they were fairly conceded and has raised no objection to the application for addition delay. Stop. Accordingly, for the reasons shown therein, and no objection of the respondent, the delay of 105 days is hereby condoned. Stop. Next paragraph, registry to diarize and register the customs appeal and list for admission hearing. In this case, allowed yes.
5. Item number 5.
Lordship, I have filed the affidavit in opposition today morning.
I'm paying for 3 weeks time to file my reply, my lord.
Yes, MS Dr. P. Agarwal, counsel for the
Respondents 2 to 5.
2 to 5 submits that act has been filed. Stop. Mr. R.S. Mishra. Please for the law 3 weeks time to file. Rejoinder.
There's an interim order, my lord. Interim order continues.
Interim order, we need to continue to the next date.
Obliged.
Hearing 6.
Please, all.
My lord, they have filed their affidavit, my lord. Yesterday evening, my lord, we have received. The state has filed the affidavit.
Allow me to file a reply to the affidavit
Objection,
filed
my
by
lord.
objection to the affidavit filed by the petitioner's lordship.
So, my lord,
The general is not here today.
No lordship, he's under some difficulty, lordship.
my lord, I'm praying this matter can be taken up on Thursday, my lord.
Will Advocate General be here
My lord, he'll be
on Thursday personally?
personally.
Or virtual hearing day on Thursday?
Yes,
But then let it be on Tuesday, next Tuesday.
or it can be taken any day.
Yes, sir. You have filed objections.
We have filed objection to that. They have filed a reply, my
Yes,
lord.
Mr. H. Karwanlang submits that in reply, an affidavit in reply to objections raised by the petitioners has since been filed. This stop. Accordingly, it's a matter for further consideration after 1 week.
My lord.
Much obliged.
Item 8 is connected, my lord.
Yes, connected. Yes, together. Yeah.
9.
Yes, what happened to Supreme Court?
Lordship, the matter has been disposed of and Supreme Court has remanded the matters back to the respective High Courts. Lordship, we are awaiting for instructions.
Yes, MS A. Pradhan, the Senate Counsel for Response 226, has submitted that the matter has since been disposed of by Honorable Supreme Court and she's still awaiting further instructions in the matter. Stop. She's awaiting. Therefore, praise the matter will start after
3 weeks, Lordship.
after 3 weeks. Is stop. Prayer is allowed. Yes, after 3 weeks and so on.
Highly obliged, Lordship.
Any mention?
May I please, Your Lordship, item 20, my lord. I talked to
Other side, who's there?
I informed Sanjeev.
Who's there?
I'm for the respondent number 6 and 7, Your Lordship.
What matter about?
My lord, school matter, my lord, regarding salary, my lord, salary and sanction post, my lord.
Why are
SSA.
you joining in?
My lord, I have not prepared well, my lord. The next week, any other day, my lord. After 2 weeks, then.
2 weeks.
My lord, deeply obliged.
Much obliged.
If His Lordship, I beg to mention item number 29, 30 and 31 is a connected matter.
What's the matter about?
This is for regularization of service.
Of those non-teaching staff, Your Lordship.
No, of the DCLP schools. Oh, no, sorry.
The Garo Hills Autonomous District. Yes, DCLP.
Why? There's a judgment in this matter already.
Yes, Lordship. The next incident, there's another, the item number 4 is actually there. Also, we have filed a rejoinder. It's connected
No,
actually.
but there was a judgment rendered by this court itself regarding
Yes.
the non-teaching staff.
Yes, Lordship.
Will that apply to these cases?
Yeah, it is applicable.
They don't have the qualifying years of service, Your Lordship. That is what is.
No,
They came into service after the act was.
No, even then, court has given some consideration. I will place the case before during the time of argument, Lordship. That item number 4 also is the same, but actually I find a rejoinder that can be actually
Tagged together, Your Lordship.
tagged together for hearing. Number 4,
Is in the
29,
other column, Your Lordship, and 29, 30, 31.
Lordship. They are all together.
Number 4. Pile Sangma.
Lordship.
Yes, sir. 29.
29, 30,
31. Huh?
31.
So, Mr. Sunso, please for. I request also this is matter after 2 weeks.
Lordship.
2 weeks, Your Lordship.
It is also mentioned that WC 404 appearing at item number 4 in the order column today is connected to these matters. According list together on the next date.
Lordship.
For hearing.
Much blessed, Lordship. Much blessed, Lordship.
May it please, Your Lordship. My Lord, I beg to mention item number 23, my Lord.
Who's for the petitioner?
My Lord, he's here.
Yes, Mr. Marab. Your objection?
No objection, Lordship.
No objection. Yes.
Much obliged.
Please, Your Lordship. Lordship, I'm praying for listing of a matter tomorrow, Your Lordship.
What's the urgency?
Lordship, the petitioner is duly appointed by the district council as an agent to run the check gate, Lordship. Now
Appointed when?
Lordship,
When was he appointed?
he was appointed, his term will expire in the year 2028, Lordship. His lease is existing.
When did he execute the lease?
Lordship, he executed in the year 2023. Thereby it was extending. Now the
It's already pending here.
No, Lordship. It's a fresh matter. Tomorrow.
Your Lordship, I beg to mention item number 27.
Number?
27. Your Lordship, if this matter is fixed for hearing, if it may be taken up after 2 weeks.
No objection, Your Lordship.
Your name?
M's aim, Your Lordship.
M's aim?
Yes, Your Lordship.
Yeah.
Supplementary list, item number 1.
May it please,
Yes, what
Your
you
Lordship.
mentioned?
Yes, Lordship. Item number 19, Your Lordship. Joint payer.
19.
Samir Chandrakar.
Samir Chandrakar.
Yes, Your
24
Lordship.
matter. Why?
2 weeks time, Your Lordship.
Why?
Not ready.
Your Lordship, I am ready for hearing, but I have taken consent from the senior counsel there, and senior counsel is saying that he will mention it. So, Lordship.
Okay, yes. Yeah.
Applies, Lordship.
Supplementary list 1.
Major
ruling
please,
motion,
Lordship.
that's why, yes.
Lordship.
Yes.
Lordship, here I am impugning my dismissal order, Lordship.
Your
Dismissal order from service. Lordship.
dismissal order?
Yes, Lordship.
Where's the order?
Order dismissal, impugn order is at page, Lordship, annexure 10, page 44. And the operative part is at page 49, Lordship. Last paragraph.
Okay.
EBRC, Khawbok Marvinang.
So when are we dismissed?
Lordship,
25?
Yes, Lordship.
Yes, sir. That's the BDAP issue notice.
Accept notice.
MSP Yang
For all the respondents.
Sponsors present and no further notice required. Respondent also have all respondents for notice required just after 3 weeks for affidavit.
Affidavit. Pleasure.
Item number 2.
Well, this is a policy which they have not given a job, my lord, to us. They have given a temporary job. There is a policy, my lord, where the state government, my lord, because
Which
of
department is it?
this is a veterinary department, my lord. The policy says, my lord, that if I donate a land or my family member donate a land,
Where's the gift deed?
gift deed is there.
Yes.
The gift deed
There's
is
a policy, yes, that
Yes.
if they
Yes, my
execute a
lord, I'm aware
document
of
for
that.
Yes,
donation
my
of
lord,
land, there must be a
Grade 4,
clause.
my lord, yes.
page 34, my lord. This is a registered gift deed that I have given, and 10,000 square meter of land I have given.
Now, where's the clause?
The clause is clause 7 of annexure 1, page 31, my lord, which has been amended on 2017 again, my lord.
Yes.
Page 32, my lord.
Heard Mr. S. Days, Leonard Counsel for Prosecution, Ms. R. Coney, Leonard G. is present except on behalf of all the respondents.
My lord.
No further notice required just after 2 weeks for affidavit. Are you in employment now?
Yes, my temporary, my lord. They are not regularizing.
3.
What is this?
She was seeking promotion
Promotion?
and
You're serving
equal
as- How many
rank,
prisoners are here?
equal pay, rank, status, and pay, lordship.
How many prisoners are here?
There are 8
of them.
8 petitioners.
Oh, a staff nurse.
They
All
are
of you are
staff nurse. They have been stagnant, lordship. They have been
One reputation maintainable against all odds.
lordship. They have been authorized to execute the
As heard
affidavit.
Mr. M. L. Longtu in a consultation. You should notice Dr. N. Muzika with C. Jala Leonard Counsel are present.
All the
As such, no further notice upon behalf of respondent, no further notice required. Just after 3 weeks for affidavit.
4.
Like,
But, Lordship, in this matter, the petitioner is seeking to seeking some correction in his scheduled tribe certificate, my lord. And to that effect, he had made a number of representation before the concerned authorities, my lord.
Correction of his name.
Of his name.
No, Your Lordship.
Oh, age,
Correction. He wants to remove his surname, Your Lordship. His
And the
mother's
reason
surname
why,
is
my
Han-
lord, may kindly allow me, page 16 is this ST certificate.
Okay, one second. 16.
Page 16 is the ST certificate, my lord.
Okay, one
The
second.
reason why I'm seeking to correct my ST certificate is because all my document, my lord, my name without the surname is there. So my lord, in order to make it simplified, my lord, I'm seeking some correction in the ST certificate. As a matter of fact, my lord, it can be said also that he doesn't want to keep his surname.
Why you don't keep his surname?
He have his own personal reason, my lord. I am not. But the fact of the matter remains, my lord, that we cannot really force him to keep the surname. Now, the interesting part is, my lord, there have been as many as 9 representation before the concerned authorities. They called me for a meeting also. I had, for a hearing. I went and the hearing was concluded, but of course, my lord, there was no response forthcoming from their end. my lord, being thus situated, my lord, I'm forced to approach before the Honorable Court.
So you already executed an affidavit also?
I have filed an affidavit, my lord. I have
only without the surname?
Yes, I have filed a affidavit, my lord. I have given a declaration to that effect. I have newspaper publication, my lord. Everything has been given.
You don't want to take another surname?
I don't know, my lord. He doesn't want to keep the surname.
But only for the purpose of a SC certificate. Why you want to change the name? The affidavit will suffice that you want the same person.
My lord, he wants, in order to make it simplified, my lord, because some document in one name, the other document in another name, my lord, because the only...
happens everywhere with passport
Please, Your
applications,
Lordship.
everything else.
Your Lordship, on verbal instructions, Your Lordship, the subdivisional officer, Your Lordship, he has informed me that he has forwarded his application to KHADC, and in fact, the petitioner is also aware of that, Your Lordship.
No, my lord, that has not been informed to me. My lord, the various correspondence from the respondent authorities would also, my lord, suggest that nothing of that sort has happened. Now, I'll take your lordship to page 37 is the last correspondence that I made.
It's not correction of name, he has a change of name. He'll amount to that. By deletion, we are deleting. Yes.
But there has to be some reason. You cannot sit tight over my representation for a number of years.
Yes, Mr. Yes, Kapala, notice. MS Eiling was present. GA, present and acceptors on behalf of all the respondents.
All the respondents, Your Lordship.
Yes. This after 2 weeks for
Obliged, Lordship.
affidavit or instruction.
Much obliged, Lordship.
May it please, Lordship, here. I've just received the corrected copy of the writ petition, Lordship, just now, because they have served the council with the incomplete writ petitions. So, Lordship, I'm praying
You are praying for?
For respondent 1 to 4, Lordship.
Just the prayer portion, my lord. Everything is there. Just now they inform us that there's no prayer portion, so we have supplied them, my lord. Otherwise, everything is intact. My lord, here we have challenged the letter dated 29/5/2026, my lord. That is at page number 22, my lord. The translated copy is page 23, my lord. This is pertaining to...
He already has another matter pending here.
Yes, initially, my lord, the Basan suspended the Sardar. Thereafter, we filed a political appeal, my lord. Then the order was stayed. During the pendency, the respondent number 5 challenged that order. And then ultimately, this honorable court has remanded the entire matter before this aim. There was an allegation that we have misappropriated some funds of the right, my lord. So while the matter was still pending, while the matter was still seized by this aim, my lord, the district council, my lord, passed this order on a purported complaint made by respondent 5 on the same set of allegation, my lord.
Respondent 5, he's there, he's a party in the other proceedings also.
Yes, my lord.
Who appeared for him earlier on?
Mr. Karlungdo, my lord. KV Karlungdo.
Lordship, this matter can be taken up tomorrow, Lordship. I'll just...
because they have...
As per this notice or this impugned order, tomorrow 3 o'clock is fixed.
Yes, my lord.
For
Yes.
hearing.
I have no instruction.
Why do you file a complaint for the council again?
No, I don't have any instruction.
On your advice?
No, I don't have any instruction right now.
They're filing complaint right and left. FIR, they are filing, my lord, same set of allegation. They have again gone to the district council. And if my lord recollects, when status quo order was passed by this honorable court, they issue a letter to us saying that the court has instructed us not to carry a Sardar. And it compelled this court to issue a clarification, my lord. So they're doing this, they're creating trouble everywhere, my lord.
Who's appearing? You or Mr. Changrai? So?
Lordship, senior counsel, Mr.
It take
Shanghai.
off some time, you inform him.
Yes, my lord.
At the end of the board, Lordship. Obliged.
6.
Motion there, no?
Your Lordship, this is an appeal, Your Lordship, for continuing the delay.
This matter, I don't know if it appeared from the parties another matter long ago. What is your, against which order you come on appeal? It's a first appeal.
Yes, Your Lordship. Against the order dated 25th July 2025, Your Lordship.
Why? What is your reason for appeal?
Your Lordship, we're challenging the jurisdiction, Your Lordship, and the respondent had filed the divorce suit on the grounds of cruelty, Your Lordship, and the issue was never framed by the trial court.
Respondent means
The husband, Your
the husband
Lordship.
on cruelty.
Yes, Your Lordship, and the ingredients were never established, Your Lordship, on cruelty, Your Lordship.
What
And
kind of
issue-
cruelty? Mental cruelty?
Yes, Your Lordship. His
Can you-
allegations are
Is there any definition of mental cruelty in any book?
but issues are never framed.
I mean, in
Your
divorce matters, is there any definition of what is mental cruelty?
and Your Lordship,
I don't think there is. Yeah, so the court can come to their own finding as what will constitute the particular facts of a case.
and Your
To one
Lordship,
person, even a simple thing will amount to mental cruelty. Right.
yes, Your Lordship. And Your Lordship, the
So why you say mental cruelty is not established?
issue was never framed, Your Lordship, regarding cruelty, Your Lordship.
But the
Regarding
decree was given on mental cruelty.
Yes, Your
Where's
Lordship.
that part in the opinion?
And Your Lordship, the statements, the evidence were wrongly recorded, Your Lordship.
Let's see the issue. Where's the issue? Where is the issue? Where the
Page 25, Your Lordship.
page 25? You say mental cruelty was never framed as an issue.
Yes, Your Lordship.
It was never framed.
Yeah, no, Your Lordship.
And decree was drawn up on,
Yes, yes.
on the basis of mental cruelty.
Yes.
No, issue number 4 will answer that. What are the reasons made a marriage between the parties broke down in your? Then, so mental cruelty be part of this issue. So it's not correct that you're saying that mental it was not framed as an issue, or that it will come within the scope of adjudication by the court. One thing, we just keep this matter, it's kind of whether I appeared for one of the parties, not in those matter, of course, but some other related matter. We'll post it on Thursday. Yes. List matter on Thursday. Yes.
7. Head of Lordship.
What is Mr. Pasmati?
Your Lordship, this is an application for striking off and for implement of necessary parties, Your Lordship.
Striking off?
Respondent number 5. He was the former secretary, Your Lordship, and I'm filing this application to substitute him with the...
Who's appearing for the respondent?
Mr. N. Sinkan was appearing for the respondent before.
Is it, where's the death certificate? Oh, he died or
He's no longer serving as the secretary.
Where's the document to show that?
He's not there. I was informed through Mr. Sinkan.
Where's Mr. Sinkan then? Can we go and hearsay?
He was the one who suggested...
oh, you bring him? We'll take up some time.
Yeah.
Daily this item number 1.
Your Lordship, I pray for some accommodation, Your Lordship, in this matter. The conducting counsel have some personal difficulties.
Who's the conducting counsel? Mr. Nongpure?
No, A.R. Prasad.
Mano, they were supposed to file a chart.
Yes?
Mano, they were supposed to file a chart.
We'll produce it at the
Mr.
time of
Nongpure,
hearing.
the counsel prays for further 1 week's time to provide a chart which is allowed by Order 26.3. Where's Mr. Nongpure? Where's the chart?
We'll produce it at the time of hearing, Your Lordship.
Where's the chart? You prepared the chart.
We'll We'll produce at the time of hearing. Still preparing.
Yes, yep, MS 100. Yes.
Lord, this is a case relating to a dispute with regard to compensation of land between two parties.
Right, they are resisting section 64. So we'll hear it.
Yes, sir.
Yes, MS 100, Learned Counsel for the praise for the accommodation due to the unavailability of the High Counsel, Mr.
A.R. Prasad.
Prasad. Stop, only this is a matter of 1 week. Yes. Along with the chart. It was 1 week, I expect next year the chart also should be on board. As allowed by order dated 26/3/26. Yes.
Item number 2.
Please, Your Lordship. It was for filing of the affidavit by remaining respondent, my lord.
One respondent remains.
What's this matter?
This is regarding challenging the
that ruling of the speaker. Yes.
Correct.
Yes, sir. Ruling of the speaker. Ruling of the speaker, my lord, and counter affidavit was filed by the main respondent, my lord, and remaining respondents were required to file the counter.
2, 3, 4, and now how many have filed?
Just 4.
3, 4, and 5 have filed as per my records, Your Lordship. I have received from 3, 4, and 5. 2 has not filed. I have not received anything from.
Lordship, I'm for 2. We filed just this morning, Lordship.
Okay, 1 second. Let's get the record straight. There was challenge to maintainability, correct?
Correct, Lordship. All the affidavits are challenges to maintainability.
Then we'll hear it.
No, in fact, by the last order, my lords, the petitioner has got time to file reply. Last order.
Particular respondent to a particular respondent, not so every just before the hearing I get another reply, and then in the morning I am served another reply. So Lordship, that's just a thing.
Fine. So number 2 you filed today.
Filed this morning, Lordship.
Number 3
We have not received.
Filed this morning. Number 4
My lord, we have filed, my lord.
Earlier, we'll do with first 2.
This morning. Okay, Mr. ASD for number 2. Then MS I submit for number 3. 4 is.
Oh, I'm appearing for 4 blocks with Mr. Ranjan.
Expanded for 4 and Mr. MC for 5 submits that affidavits have since been filed. Stop. This is a matter of 2 weeks for rejoinder. And we should we hear on that day itself? You advance copies, then we
Please,
can.
Your Lordship.
Yes.
Please, Your Lordship. The unfortunate part is this is a 2023 election. Now we are at 26 and we are still on this
They have
issue.
to file rejoinder, my lord. Now they have not filed.
I understand. There's one issue at hand. Is basically the rules and the procedure versus the constitutional scheme under the 10th schedule.
You file the rejoinder. We'll hear it. Yes.
Please, please.
Yes. Yes.
May I please, Your Lordship?
Yes.
As per my senior instruction, we will file the rejoinder, Lordship. I have not received. No,
That's
we
up to
will
you.
file.
Yes, party submit appeals complete.
My lord,
just
I
for
need-
hearing.
My lord, I need permission, my lord, to make changes in my impleadment application. My lord, I had made a mistake last time.
Your application has not been disposed of yet.
No, ma'am, my lord. My
Then
lord,
this
I made a mistake here, my lord, by making the CAM as a member. I need to change that, my lord. I need permission.
I think. Miss case for what?
For pleading Garo Hills, GHDC, my lord. Yeah. I made a mistake here.
Yes. Have you replied to this one? I mean, sorry. Have you received notice of this miss case?
I made a mistake there, my lord, on the parties. I need to change that, my lord.
Yeah, this is.
No, he should be right there.
No, I don't understand this, Miss Kiss.
My
Where
lord-
have you named the CM?
My lord, at
Where
page
the
number
body of
5.
the petition have you
At page number
have you mentioned
of
it?
my impleadment, my lord.
Yes, where the body of the petition you mentioned it. It has to come in the body of the petition, not in the cause title.
Then my lord,
Yes, you withdraw it and file a fresh
yes, my
one.
lord. Kindly
MSOI
permit me.
Bank. Huh? Disposal. But it's disposed of on 7th of May.
No, my lord. There's a fresh one that I had filed. This is 34th, 2026. Because my lord, I made a mistake. I filed a fresh one and I made a mistake. 34th, 2026.
34. Fresh one. It's disposed on 15th April.
Oh, my lord, this
You kindly settle the record.
I'll do that, my lord. Let me go through the records.
This is a matter of 1 week is to allow the counsel of the respondents.
Yes, my lord.
Is to clarify the status of the MITS applications filed in the matter.
5. Who's obliged?
Well, I will be filing my affidavit within a week, my lord. I have signed already.
This matter is proceeding ex parte against the private respondents.
Please, Your Lordship, I am entering appearance on behalf of responder
number
4, 5, and 6.
The matter had already proceeded ex parte, my lord, against them.
I humbly request Your Lordship to kindly allow me to file an
only ex parte,
application.
then you have to come application.
Yes,
Yes, Your Lordship.
Okay.
Yes.
Yes, sir. Mr. S. Taylor, counsel for the respondents 1,
1 to 3 minutes.
On place submits the application filed in the week. This after 2 weeks for the joint if any.
6.
Your Lordship, I've already filed the rejoinder to the affidavit of respondent 1 to 5. I'm praying for time.
What about 6?
I'm praying for time, Your Lordship.
You already paid for time. How many times you praying for 6?
I've prayed for 2 times.
The third time?
Yes.
You're for 6? Yes, Mr. G. Sinkram. Prays for the Lord final opportunity of 2 weeks to file the joinder to the affidavit filed by the respondent number 6. This is thereafter for hearing.
7.
Yes, Lordship. Lordship, here I have received the counter affidavit yesterday, Lordship. So I need some time to go through.
Let us wait for the 2 weeks time allowed for rejoinder.
If any, Lordship.
We have just served him.
I have
Filed
just
yesterday
evening
evening.
I have received it.
He has to go through it. Means.
Submits that he has just received a copy of the affidavit of position. He prays for 2 weeks time to file rejoinder if required. Just thereafter and so on.
8.
Please, Your Lordship. Lordship, we will file a rejoinder. We are in the process of
What's the matter about Mr.
Your Lordship, that regarding that this is regarding the land in Sora.
In the resort.
Who filed agenda?
We will file.
What's happening now there? Still interference carrying on?
My lord, they are functioning because, Lordship, there was a direction that the state police, through the police department, will provide my necessary law and order situation, my lord. So we are doing that.
It's strange.
But one thing you see what's happening is very disturbing, that in the guise of boundary dispute, you can't stop, this business activities going on, like tourism activities. You can't, then what will happen? People depend on livelihood now, especially in this area. A lot of people depend on the livelihood for tourism.
That is correct, Lordship. But the thing is this, the Sora CM is the important respondent.
Sora's aim, he is toothless now.
Because under, he called the petitioner, and the petitioner, on his call, petitioner filed the FIR. And the direct respondents in the legal No. It is stated in the writ petition, Lordship.
Yes, what you have to say?
Lordship, actually the acting CM is supposed to take cognizance of this boundary dispute, Your Lordship.
But he's
That is not a fact, Your Lordship. That is what they have been submitting, Your Lordship, that he is not empowered, but he is empowered, Your Lordship. For another boundary dispute, Your Lordship, he is taking cognizance. He is the
who's appearing for the acting CM?
They are appearing, Your Lordship.
No.
In another case.
No instruction.
Not in this matter. In another matter, they are appearing, Your Lordship.
So what do you want the court to do?
Let him file the reply, Lordship.
You file rejoinder?
We file rejoinder. Are we in the process of filing?
Mr. Carlindo submits that the rejoinder the affidavit filed by respondent 6 and 7.
6 and 7.
We file the course of the day. This matter of 1 week for the orders. Then we'll see.
Obliged.
9.
My lord, this is a contempt petition, Lordship. With respect to order dated 3rd December, Lordship, it passed an order for reinstatement, Lordship. But they have not reinstated me, Lordship. And what has happened is, unless I am reinstated, my pension will not be processed, Lordship. My pension is
retired now.
He's retired,
retired
Lordship.
on
3rd
December, my lord.
December, Lordship.
In fact, on the last day, we showed your lordship.
A categorical order for reinstatement.
Lordship. This is very unfortunate, Lordship.
On the last occasion, my lord, when the matter was taken up, we already placed before your lordship a communication dated 27 April, whereby we have communicated to the petitioner, my lord, about the.
That order is neither here nor there, Lordship.
He's from Guwahati, my lord. I'm assessing.
Where's the affidavit now?
My lord, I'm praying for 2 weeks, sometime now. That has after 2 weeks, my lord.
Lordship, they are holding up my GPF also, Lordship. GPF has nothing to do with this matter, Lordship.
Person, whoever is a contemptor.
Lordship.
There's a contempt. It's not a writ petition where you seek time. You have the orders of the court, and if they're willfully being violated,
they're willfully being violated.
Taking more time, affidavit. Sorry.
This is just second occasion, my lord.
Doesn't matter. The contempt matter.
Waiting for some instruction.
You should be happy not asking for personal experience. You know, in earlier occasions, contempt matters were taken very seriously. Not like now.
I agree.
Where the just being filed thick and fast. Now, when the contempt is filed, a notice received that the contemptors appear in person. And then he has to tender his apology, then he files the affidavit, or he doesn't tender his apology, whatever reasons.
Wow.
You take it lightly, then it's very difficult.
I'm only praying for some more time. We'll file by 1 week.
Mr. I. Kharmujai, the counsel for the respondent, has prayed for further time to
1 week.
File affidavit putting a record the order of reinstatement.
Yes, sir.
Yes, it is noted that similar prayer was made as far back as on 7/05/2026. This court notes its displeasure. Failure to file the affidavit within a week from today. If the affidavit is not filed within a week by today, the contemptor number 1, the contemptors number 1 and 2 appear in person before this court. Yes. Yes.
10.
May it please, Lordship. Lordship, I have already filed the service of affidavit, Lordship, on the last occasion.
Please, your Lordship. Lordships, I have instructions to appear for responding.
Lordship, there are certain developments. This gentleman has been issuing contemptuous notification.
I'm not a gentleman. I'm an acting lingdo.
Issuing contemptuous notices?
No, Lordship. Lordship, I am an acting lingdo of a Guru, Lordship.
Lordship, the status quo is operating in my favor, Lordship. Lordship has never set aside the...
Lordship, the entire matter is seized off by the district council. Till date, the district council has not decided to matter.
Lordship.
And when I had filed the writ petition, Lordship,
it's been disposed of.
It was disposed of, and
it was
Lordship
disposed of,
directed
and
to
what
maintain
is
status.
Lordship, the translated copy is in the back, Lordship. The next. I don't have a copy. Two notifications. Two notices.
You are?
I'm Bringlan Palyar. He's the acting lingdo of the Guru.
You appointed, yes?
Yes.
Lordship, kindly come to the High Court order, Lordship. Page number 32, Lordship.
This is by the acting's aim. He acted in...
Acting's aim.
Lordship,
they have come. Lordship, they have challenged.
Yeah,
they have
let
challenged.
him file affidavit.
I'll file my affidavit.
Yes, you bring the record if you want to. Mr. Emil Nongpur has entered appearance today on behalf of the respondent number 1 and 2.
Only one.
How can you have pro forma respondent in a contempt application?
Lordship, this
respondent number 1.
Because he is not the.
No, only number 1.
Only number 1.
Only number 1.
Only number
Mr. Nongpur.
Lordship, only one.
Lordship. Stop. He is allowed 2 weeks time for affidavit. Stop. Mr. Dakhar has also drawn attention of this court to 2 notices issued by the acting's aim.
Acting lingdo.
Acting lingdo of of Paler Mokarda, which he asserts is contemptuous. He permitted to bring the same record with additional affidavit just after 2 weeks.
Okay.
Offline.
11.
And I have filed my affidavit today and I have served a copy to my friend.
Only today, I have just received lordship today morning.
I'm appearing for respondent number 3, Manor. We have also filed our affidavit. There's a secretary.
You file affidavit?
You file affidavit.
Actually, we have.
But affidavit or not?
The respondent number 2 also make about that.
Respondent number 2 is not a necessary party.
What is the order stated to be?
Yes, sir.
Where the order stated to be violated?
That order, my lord, that is in the page.
Your Lordship will recollect this is the case regarding the PIL, the removal of the appointment of judge.
Yes,
Page 20 is the relevant.
Page?
Page 20, Annex 2.
Relevant is page 24, man.
Now, what do you say is violated? Why? It's the same person has been appointed again.
Yes, same person has been
correct.
Same person has been appointed.
Yes. So, my lord, in this case, the district council at the time of the PIL did not bring it to the notice of this court. That is far back as on 2022. My lord will see Annex 8, page 8 of the affidavit filed by me, respondent number 3.
Page
8.
Yes.
No, that's far back in 2022. In fact, appointment of judge, of both the civil judge and the judge of the criminal courts, were forwarded to the government. Your Lordship will see that with regard to the with regard to the above subject and reference, I am to inform you that the Executive Committee GHEDC by memo dated 1/8/2022 had appointed Shri P.S. Marak, Assistant Judge, as Judge Civil and Family Court, and Shri B.R. Marak, Assistant Judge, as Judge Criminal Court, and forwarded to the District Council Affairs, Government of Meghalaya, for approval of the Governor. In this regard, the District Council Affairs, Government of Meghalaya, by its letter so has instructed this office to obtain approval of the Honorable High Court to the above appointment. So this was never brought to the notice of this court. I don't know for whatever reason, because that time I was out of office. This affidavit, the earlier affidavit, was filed by the... Moreover, my lord, if I can add, my lord, if my lord may kindly produce my affidavit that I have filed, my lord, which has not been brought on record, my lord, by the petitioner, my lord. Page 19 of my affidavit, my lord. We'll come to that now.
Page 19, we have only till page
Yes, page 19.
Page 19, my lord. My lord may kindly see the paragraph 4, my lord. 4-5, my lord. Under counsel for the applicant and submit that he is that the applicant is not so and so to discharge his function as an additional judge. Para 5 is very important, my lord. It is for the district council to decide on the said issue. It is to expect that the competent person shall be appointed as judge of the district council, my lord. Now, liberty was given to us, my lord. I had filed an application, my lord will recollect, for modification of the first order passed by this court in the PIL. I said that I am not qualified to be appointed as an additional judge. So I was holding a dual charge, my lord, as additional judge as well as secretary of the executive committee. Now, an interim order was passed in the PIL saying that I should continue as additional judge, and another person should be appointed as secretary of the executive committee, which was done. Then I filed an application, my lord, for modification of that order.
Yes.
And that order was passed, which my friend had just read. So anyway, my lord, what is the order of this court, the final order of this court? Because that order has been merged. Okay, my lord will come back to page 24
of the affidavit
of the writ petition, of the contempt petition.
Let us go through the entire.
Yes.
Yeah. Today, Mr. D.A. Learned Counsel appearing for GHADC has tendered an affidavit of Shri P.R. Marak, in charge Secretary to the Executive Committee. The said affidavit is taken on record. Sub-para 3 to 7 of para 4 of the said affidavit read thus: that in compliance with the order passed by this Honorable Court, Shri S.R.R. Marak is no longer functioning as the Secretary to the Executive Committee. That Shri P.R. Marak has been appointed as in charge Secretary to the EC with immediate effect. That similarly Shri R.N. Marak Lasangma has been appointed as in charge Secretary in the Legislative Department GHDC. That further it was decided that Shri S.R.R. Marak is to continue functioning as Additional Judge District Council Court. That furthermore it was decided that a full-time judge for the District Council Court shall be duly appointed as per due process and in compliance to the provisions of the 6th schedule of the Constitution of India and the Garo Hills Autonomous District Administration of Justice Rules 1953. In view of the aforesaid, nothing survives for further consideration in the aforesaid petition. Needless to state that the appointment of a full-time judge for the District Council Court shall be done in accordance with law. Now, what I am saying a lot is right from 2022, in fact, the appointment of a judge was already done.
Yes.
It was sent to the government for approval. But this fact was never brought to the notice of this court. I don't know for whatever reason.
To examine, yes.
Your Lordship, I just got it today only. But Your Lordship, this affidavit filed by the respondent number 1 is contradicting. Kindly see the because they have not given the proper page. This one, no page is written, but the annexure AG is. It's written, but what page number is it? So difficult to because they don't.
Now also they have come up with the same
Lordship,
letters,
I will assist the court properly. Let me go through the affidavit filed by all the parties because I have not gone. It will be like an.
But the fact is this, my lord.
Yes, Lordship.
My learned friend, Mr. Sangma's client has suppressed the fact that liberty was given to district council to decide, my lord, whether the person who was occupying the additional judge was competent or not, my lord.
Then you will close the contempt.
No, Your Lordship, I will go through the affidavit. Then I will make my submission.
The affidavit perhaps 1 has been filed today itself.
1 and 3.
It's filed earlier today itself. Affidavit 1 over 3 is already on board. This is matter after 1 week.
Lordship.
If they had brought this to the notice of the court,
No. Otherwise, see, you examine it. Otherwise,
yes, Lordship. There's many things that I want to
many
make.
things or less things you don't know, but
no, Your Lordship.
If no willful contempt is made out,
it is there, Lordship. I will satisfy one. Much less, Lordship.
Please, Your Lordship. We're supposed to file bank. Respondent number 4 and 5 is supposed to file affidavit, but before the affidavit, Your Lordship, the respondent number 4 and 5 was name in person. So that name in person, the branch
number?
manager,
He's a
branch
yes,
manager, name in person.
I
so
named
there's
them
an
in
issue.
doesn't mean it can't appear of him.
He can appear, but the problem is that it's a transferable job. So later, if he shifted to another branch, that'll be an issue. Lordship, there's a miscase in the process of filing. Allow me.
Miscase?
There's a miscase for striking off the name in person, Your Lordship.
After it's been filed by.
Lordship, we have filed an affidavit with
Status report. I received it, my lord. I have to go through and seek instructions from my client what he has to say in these comments.
Yes, after it's been after it being record the report of investigation in compliance with the order dated 7/5/26 have been filed by the respondent number. Spinner Police. Spot number 1.
1, 2, 3.
Hello, it's point number 2.
Corner number 2. Stop. Mr. S. Marpan submits that and the Mr. application is being filed for striking of certain parties from the certain names array of parties. Stop. This after 1 week for further orders.
13.
Lordship, I have instructions in this matter. Lordship, the government is trying to constitute a managing committee. Lordship. I have the
You're appealing for whom?
For the private respondent, the current managing committee. Lordship. I have the communication.
Where's he's appearing here, Mr. Dev Jr., correct? Where's Mr. Dev? Not that Mr. Dev, the other Mr. S.
Don't know.
Are you aware of this?
Yes, this is issued by the government.
Are you,
from the directorate,
you're appearing for the seat respondents?
My lord, from the directorate, of course I don't have a copy of this letter, my lord.
How you don't have and he has?
Lordship, it has been addressed to me, the next letter. Lordship.
But I have the direction which was issued to the...
Well, where's your arguing counsel?
Yeah, Lordship.
You get him?
Lordship can dispose of them too. This prays for reconstitution of the managing committee.
Yes. He was here just a fraction of a second. Mr. D. What's Mr. D? His opinions matter. Whose opinions matter?
SDEP.
You get him? You won't keep these matters lingering unnecessarily. After some time.
14.
Five is whom?
May please the
For 5.
No, he's for 5. I'm for. I'm for 1 and 2, Lordship.
I've received the affidavit, Your Lordship. But then the amount also is not disclosed, Your Lordship.
Lordship had directed me to reach out, but unfortunately, our SP Cybercrime had reached out to the relevant SP in Karnataka, but we haven't received anything yet.
What do you see in the affidavit, Mr. Marpan?
Lordship, I have enclosed, Lordship, just first of all the notice from the concerned cybercrime,
the same thing again.
and also email after that, Lordship, page 6, 7, 8.
What's the amount?
8, 9. Amount, Lordship, page, can you come to the last annexure, which is at page 11, page 11, Your Lordship, annexure 3. So the last account number, Precious Stone Marvin, is the petitioner, Lordship. So the balance on the date of debit freeze on 9
The balance now. What's the amount?
Amount was not informed.
How is it possible?
That's what there's email correspondent from our end also, Lordship. They now have not given us the direction as in the disputed amount. Lordship.
Lordship, respondent number 2 has actually sought that information, but we have not heard yet. We haven't seen
I mean, the banks, no, you can't just recycle your instructions and say that you don't know. You're freezing N blocks. How many accounts? 1, 2, 3.
Instruction
4,
as
5,
to the
6
disputed amount.
for a certain amount. You can't say
Disputed amount that was not provided, Your Lordship. We have our email is there, Your Lordship. I have enclosed the.
Who's the person concerned here?
Person concerned is the Cybercrime Police Station, which is here in Karnataka.
But in spite, it is reported by Mr. ASD paying for respondents 1 and 2. In spite of the best efforts, I have not been able to obtain specific instructions from the counterparts at
counterparts of respondent number 2 in Karnataka.
Counterpart of respondent number 2, that is the Suburban Police Cybercrime. Was this Chikabalapura town?
Chikabara town.
The respondent number 3.
Number 3. Number 3. Number 3. No? Karnataka. An affidavit has also been filed by the respondent number 5, which also does not disclose the amount which has been kept in, does not disclose the amount from the petitioner's account that has been kept in debit freeze. Stop. It is not understood as to what circumstances this information is not forthcoming. Stop. Next, it is expected next day that this information should be available from the bank, notwithstanding any other circumstances. Just after 2 weeks. Otherwise, you have to take some.
Otherwise, in the affidavit of already make a statement that we have.
You're just recycling it.
If the court directs, we will do it.
Know how much of the amount is frozen.
That is not given.
What's the disputed amount in this account?
We just asked to freeze and that's it. Yeah. So it's up to the state.
Suppose he said 10 accounts, freeze all of them. A, B, C, D. You don't know how much amounts, disputed amount.
Well, the direction is only to freeze, Lordship. That's the only.
SAFC is very unfortunate the way they're handling this.
Lordship, they are email, Lordship. We have sent an email immediately also to.
Email won't help.
But then no response.
You don't have any internal mechanism to handle this kind of situations. All other banks are having the kind of problems that you're having.
Moreover, Your Lordship, it's been frozen since 9 January.
9 January.
And then 17 lakhs is lying in account.
Only 41,000.
41,000
plus.
As on the day of freezing.
Account.
15.
Wait, Lordship.
It's for hearing.
It's for hearing, well, it's very short hearing.
Come for orders then.
I don't know, well, it's very short. I will only argue for 5 minutes. Everything is there in the petition itself, my lord. In fact, I am only pressing on for them to act on their own memorandum. Now, my lord, what is this case is that, my lord, I was issued a passport in the year 2016. My passport, I have applied for renewal of my passport. So, while renewal of my passport, my lord, some cases have been filed against me. Out of all the cases filed against me, my lord, one case has been charge sheeted. I am facing a summary trial for a very small offence. Now, my lord, from that court, I applied for an NOC. The court passed an order stating that I was never arrested, there were no bail bonds, so there cannot be any restrictions. So the question of NOC does not arise. So thereafter, my lord, when I made an application for renewal, my lord, police verification is sought for.
When was your passport first issued?
In 2016, my lord, in the year 2016.
That time was any cases pending?
No. At that point of time, there were no cases pending against me.
Yes, passport 2016.
And thereafter, my lord, when I filed for renewal.
Registered against you which years?
My lord, the cases which are here, I'll just give you the details. All the cases are after 2016, my lord. Only one of them has been charge sheeted, and in that particular case, my lord, I have applied for an application, and the application order has been passed. Now, my case is, my lord, mere filing of an FIR. Mere filing of an FIR will not automatically let them to refuse or renew my passport. Of course, if a case has been charge sheeted and a court takes cognizance of a particular case, cognizance happens when a charge sheet is placed before the court, then the particular court is set to take cognizance of a particular offence. In such cases, my lord, I am to apply for an NOC from the court. Now, I have done that. Now, when I file for, my lord, renewal, they say that from the police side, they have given an adverse report. Adverse report stating that some other cases are pending against me. Now, lordship will kindly come to page, my lord, the office memorandum, my lord, at page 21. My lord, this is a memorandum of the year 2019. This is specifically for, my lord, in those cases, while, my lord, people have criminal cases pending against them. Now, this memorandum clearly.
One second. Yes, if the court takes cognizance, then it will be a different proposition, right?
Yes, my lord. Only in one case the court is taken cognizance, and I have filed an application.
That will be a matter pending.
No, my lord.
FIR or under investigation also will not, amount to until the court takes cognizance.
Absolutely, my lord. So the only case where the court has taken cognizance, my lord, the court has passed an order. If lordship will come to page 26
of the writ petition.
Of the writ petition, and the order is at page 27, my lord. Yes. If I may read, my lord.
Case record is put up before me. Learned counsel Shri Abhimanyu Singh is present for the petitioner. Learned APP so-and-so is present for the state. The petitioner has filed an application seeking that the court issue a no objection certificate for the accused so-and-so to renew his passport. He submits that due to the provision of section 6(2)(f) of the Passports Act, he apprehends that his renewal may not be entertained without an NOC. In simple terms, the petitioner is seeking that the court issue an NOC. What the court can do is clarify that in connection with this present case, being GR 64A 2025, there is no restriction placed by the court in respect of the movement of the accused outside its jurisdiction. Had there been bail conditions or other similar restriction placed, then the consideration for this application would have been on a different tangent. These need not be entered into now. Question of so-and-so. So there is no question of giving an NOC also. Now what remains is, my lord, the other cases. Now as far as the other cases are concerned, my lord, if I may take lordship to page 21. My lord, page 21 of my writ petition, my lord. This is office memorandum dated 10th October 2019. If I may read, my lord, the relevant portions, my lord, I'll start with the subject. Issue of passport to applicants against whom criminal cases are pending before a court of law in India. Reference is invited to notification so-and-so dated 1993 regarding issuance of passports to applicants who have criminal proceedings pending against them and whose applications would attract the provision of clause 7 of subsection 2 of section 6 of the Passport Act. Now section 6 imposes certain restrictions in renewal and issuance of passports, and one of them is a pending criminal case. So this particular, my lord, office memorandum clarifies that, if lordship will see, if I may read para 3, page 22, my lord. It may be noted that applicants may be refused passport only on grounds mentioned under section 6(2) of the Passports Act 1967. Section 6(2)(f) of the Act states that passport authority shall refuse to issue a passport or travel document to an applicant on the ground that proceedings in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India. GSR 750E dated 25th August 1993 was introduced to give relief to such applicants against whom criminal proceedings are pending before the court of law in India, but who may need to travel abroad for some urgent business. With an undertaking under so-and-so, under CSR 570E and an order from the court, an applicant would be issued a short validity passport of 1 year validity and for the period specified by the court. Para 4, it has been noticed that there are increasing number of references being received regarding passport applications attracting section 6(2)(f). It has also been brought to ministry's notice that there are a number of complex issues involved while processing such application. During the proceedings in a recent court case, the Honorable High Court of Delhi in WPC so-and-so has directed guidelines be issued by the ministry, reiterating the procedure for processing of such applicants and emphasizing that such applications need to be processed with due care and diligence. Now, my lord, if lordship will now come to page 23. This is my case, my lord. Page 23, lordship will see para 5, Roman 5. My lord, if I may read. In case where the first police verification is adverse, second police verification may be generated. While a secondary PV is generated, it should be accompanied by a detailed letter seeking clarification regarding the pending criminal cases against the applicant and the status of these cases. Apart from generating second police PVR, the passport officers may, if considered necessary, call for discreet inquiry through the police authorities by sending the court orders submitted by the applicant, or even seek verification from the other government agencies, departments, or as the case may be. In case where the secondary police verification is also adverse, it may be examined whether the details brought out in the police report match the undertaking submitted by the applicant. It may be noted that mere filing of FIRs in cases under investigation do not come under the purview of section 6 clause 2(f), and that criminal proceedings would only be considered pending against the applicant if a case has been registered before any court of law and the court has taken cognizance of the same. Now, my lord, I'll place one judgment, my lord, to substantiate my argument, my lord. This is a judgment of the Supreme Court, my lord.
Now, where's MS Ailingwa? Second verification been done.
Yes, Your Lordship.
Adverse.
Yes, Your Lordship.
On a question on the ground of pendency of criminal proceedings. Notwithstanding, did they take into account the order of the court clarifying that there are real conditions do not prohibit him from travelling?
Your Lordship, if we look into the prayer of the petition, Your Lordship, is renewal of the passport. We are not the issuing authority, Your Lordship.
No, not issue, but then on the basis of your inputs, the renewal or the issuance of renewal will be done. Now the thing is that second verification is also adverse, correct?
Yes, Your Lordship.
But then have we put an affidavit whether the court orders take in consideration with regard to the restriction on movement?
We have not stated anything as such. We have just stated facts, Your Lordship, that there are 2 criminal cases pending against him. Investigation is pending, Your Lordship.
Investigation will not really.
It's for the passport office to decide, Your Lordship.
Well, this judgment will deal with that aspect. Well, I'll read para 10, my lord. Para 10. A flag marked. On a plain reading of GSR 570, my lord, the notification which I read out earlier, does two things. First, it recognizes that persons facing criminal proceedings are not to be treated as absolutely entitled to a passport. Instead, it permits such person to obtain a passport, notwithstanding Section 62F, where the concerned criminal code has applied its mind and passed an order in relation to issuance or use of the passport, and where the applicant furnishes an undertaking to appear before the court as and when required. Secondly, it structures the exercise of that exemption by tying the validity and use of the passport to the terms of the court's order. Thus, when the court specifies a period for which the passport is to be issued, the passport authority must honor that period. Where the court does not stipulate any period, the notification provides default rules, including issuance of a shorter period, ordinarily 1 year in appropriate cases. What the notification does not do is to create a new substantive bar beyond Section 62F, or to insist that the criminal courts must in every case grant a prior blanket permission to depart from India for specific dates as a jurisdictional precondition to the very issue of or reissue of the passport. The OM dated 10/10/2019 does not create a new regime. It reiterates that GSR 750E must be strictly applied, explains the procedure where criminal cases are pending, and makes it clear that a no objection certificate of permission from the criminal court read with the applicant's undertaking may override an adverse police report with reasons recorded by the passport officer. So even if there is an adverse police report also, my lord, this particular memorandum will override that. So that will not be a ground for the passport authorities to refuse my renewal of my passport. It also contemplates situations where more than one court is dealing with the matter and indicates that the orders of all such courts are to be read together. The OM is thus an administrative restatement of the position under Section 62F, Section 22 and GSR 7 so and so.
Yes.
Yes. And also, if I may read para 25, my lord, last.
Yes.
Para 25 says, in the light of the above discussions, we are unable to sustain the approach adopted by the single judge and the division bench. Both have treated Section 62F as an absolute bar so long as any criminal proceeding is pending, without giving full effect to the statutory exemptions mechanism under Section 22 and GSR 750E, and without adequately appreciating that the criminal courts actually dealing with the applicant's cases have consciously permitted renewal, and while retaining stringent control over any foreign travel, they have in effect converted a qualified restriction designed to secure the presence of an accused to a near permanent disability to hold a valid passport, even when the criminal courts themselves do not consider such a disability necessary.
What's Section 22?
Well, Section 22 talks about exemptions, my lord. It's a power to exempt, where the central government.
Where is that?
Section 22 of the Passport Act.
After all these forms.
Lordship has the Passport Act.
Yes. Repeal. Oh, sorry.
22 power to exempt. Yes. Where the central government.
One second. Yes.
Where the central government is of the opinion that it is necessary or expedient in the public interest to do, or it may by notification the official gazette and subject to such conditions, if any, as it may specify in the notification, exempt any person or class of persons from the operation of all or any of the provisions of this act or the rules made thereunder, and often as may be cancel any such notification, and again subject by a like notification the person or class of persons to the operation of such provisions.
Yes. Yes, Dr. Mojika.
The only thing is, my lord, if I may just place this, my lord, on the last occasion I said, my lord, I saw the opportunity of going to foreign training, football training, my lord, in the month of December. There is some urgency, my lord, and my lord, the law clearly provides that I am entitled to renewal.
There's under 9 category also football now?
Yes.
Yes. Where is this pay for right?
This is a local club, my lords. I believe it's a club from Malki, if I'm not mistaken.
Yeah, for right.
Yes. Yes.
Yes, my lord. But the only difficulty is section 6(2)(f, my lord. Now, your lordship kindly see 6(2)(f of the Passports Act.
Yes.
6(2) says, my lord, subject to the other provisions of this act, the passport authority shall refuse to issue a passport or travel document for visiting any foreign country under clause C of section 2 of the section 5 or any other or more of the following grounds and no other grounds, namely, F, my lord, it says that proceedings in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India.
So you see this 6(2) as mandatory. It shall refuse.
Shall refuse, my lord. Now,
Yes.
now, my lord, this has been interpreted pending before a criminal court in India. The Karnataka High Court.
Pending means charge sheeted. Yes.
Charge
Yes.
sheeted.
Yes.
The pending investigation is not a problem. So we abide by that. Now, because in one of the matters it has been charge sheeted, my lord, and he even applied for permission from that court, my lord, and the permission has not been granted. At this stage, our hands are tied, my lord.
It's not been granted which court?
By the trial court, my lord.
But that
It's not required to be granted.
He placed earlier on.
But my lord, as it stands, 2 cases has not been charge sheeted, is under investigation. 1 case has been charge sheeted, my lord. So he comes with under the 6(2)(f, my lord.
No, that 6(2)(f is clarified by their own notification, my lord. It's very clear.
This officer member doesn't say anything, my lord. This officer, my friend was reading.
But the Supreme Court judgment clearly, my lord, says that. In that case, the person has been tried by NIA and CBI courts. Very serious offences. There also the court has come to a finding that you cannot stop me from renewing my passport.
But then it also says there that if you override the adverse report also, if the order of a court.
Even if there is an adverse report also.
Yes, override. But in your case, it's not overridden. It just said that we're not giving NOC because
it's not required.
It's not required.
I'll explain why, my lord. Normally, my lord, if a person is facing a criminal trial, my lord, if I was facing a criminal trial for an offence where I was arrested or I was supposed to furnish bail bonds, then my lord, the question of the court granting me NOC would have arisen. Here the court has made a very categorical observation that there are no bail bonds. No restriction has been placed because you are facing a trial over here. This question of NOC does not arise. So that itself is an order passed by the courts which should satisfy the passport authorities that there is no embargo for him issued by the court to either renew his passport or to travel abroad. Basically, in the other sense, there is no flight risk.
No, we have to go as per law, notwithstanding anything else.
Para 10, 11, my friend was reading, my lord, for the Supreme Court decision.
Yes.
Let's read once again, my lord.
Yes.
Para 10. On a plain reading, GSR 570 does 2 things. First, it recognizes that a person facing criminal proceedings are not to be treated as absolutely disentitled to a passport. Instead, it permits such person to obtain a passport notwithstanding section 6(2)(f), where the concerned criminal court has applied its mind and passed an order in relation to issuance or use of the passport, and where the applicant furnishes an undertaking to appear before the court as and when required. Secondly, it structures the exercise of that exemption by trying the validity and use of the passport in terms of the court's order. Thus, where a court specifies a period for which the passport is to be issued, the passport authority must honor that period. When the court does not stipulate any period, the notification provides the default rules, including issues for a shorter period, ordinarily 1 year in appropriate. Where the notification does not do so, does not do is to create a new substantive bar beyond 6.2f or to insist that criminal court must in every case grant a prior blanket permission to depart from India as specified. So, this para 10.
So you go back to court. If you get
my lord, if I may just one small reply.
Place your invite.
Kindly, my lord, what my learned senior has read, where the concerned criminal court has applied its mind and passed an order in relation to issuance or use of the passport. But it does not specifically say that there has to be an NOC, there has to be an order, and there is an order over here.
Read this again. Relax. Yes, just reading. On a plain reading, yes, says does two things. First, recognizes that persons facing criminal proceedings are not to be treated disentitled of passport.
Yes.
Absolutely. It permits such persons to obtain notwithstanding section 6.2f, because 6.2f says that if the criminal case pending again, it shall be refused. Right?
Yes.
But it allows where the concerned criminal court has applied its mind and passed an order in relation to issuance or use of passport, and what applicant furnishes an undertaking to appear before the court as and when required.
Yes, as and when required.
Yes.
My undertaking
So
maybe to appear before the court.
Secondly, it says that exemption by timely validity of use passport. Now you're saying that you're going to go for a certain tournament, right?
For a week.
Then the court can direct the passport authorities, notwithstanding 6.2f, that for issue the passport for limited period. That's all.
My lord, what I would pray, my lord,
Yes.
it appears that this Supreme Court decision is very recent, my lord. This obviously was not placed before the trial court. So, my lord,
The trial court has examined all the aspects.
Fresh application, my lord.
Trial court has examined all the aspects.
Any aspect. I'm not. It's a very what do you call it, superficial way.
If I
that you know that there's no NOC is required because there are no bill conditions. You
So
can't.
why?
Now the thing is that this relation to a matter where cognizance has been taken, where you've been charge sheeted, right? So the thing is that the court must examine the correct perspective with issuance of passport and whether what does the act provide and what is judgment is very material that way.
My lord, what is my submission is, my lord, the judgment only says, the judgment does not talk about NOC from the court. The judgment talks about an order.
NOC from the court. It's just a court applies his mind to the prayer they
That
make
is what,
before
my lord, I am submitting, my lord. That is what I am submitting.
Not this court applies his mind. That court applies his mind.
Exactly. So that court has applied his mind and passed this order.
Otherwise, you know what order will come.
But only thing is, my lord, if I may just try to satisfy lordship just once, give me 2 minutes.
You take instructions.
If this,
you take instructions which is in view of his judgment.
If this,
and you know what order is going to come.
Well, I can. In fact, my lord, the trial court should have just said NOC because there is no flight risk as it is. No, well, in that case, my lord, I may be disposed of giving a direction to I may be given an NOC and thereafter, my lord, on the strength of the NOC, passport may be granted. But that's the proper
law. Court gives the NOC.
No, not this court, my lord. Of course, not this court. I am not facing trial.
Instructions first.
Let this matter come next week, my lord. There is some urgency.
This is a matter on the prayer, Mr. Kisich Putin, that one would allow him to obtain. The judgment is very important. I've not seen it before, so yes. Yes, Mr. Sangma.
Obliged.
This matter, your lordship, the government is supposed to file the affidavit. Not filing.
Awaiting instructions in this matter.
When was it filed?
Well, this came up in the month
filed
of
on April 2026. 16 April 2026.
You are appearing for?
For the statement.
And she's appearing for? You are assisting Mr. Parasachi? Yes, as prayed for a 2 weeks time allowed, yes.
Most blessed lordship.
All right.
May I please your lordship? Lordship, I am appearing for respondent number 1, lordship, and we'll file our affidavit during the course of the day, lordship.
Who is appearing for 2 and 3?
In respect of respondent number 2 and 3, lordship, steps were taken, lordship. However, it has come unserved, lordship. So I am praying for taking fresh steps, lordship.
Number 1 is?
A Brahma, lordship.
You are the?
Monitoring committee, lordship.
Your name? Your name?
A Brahma, lordship.
A Burman?
A Brahma. BRH, lordship.
Yes, Mr. A Brahmo has an appearance on behalf of respondent number 1. So, however, with regard to respondent 2 and 3, Mr. Chanda, what is the submission?
Lordship, it has come unserved, lordship.
Just said. What Mr. Chanda? However, regard response 2 and 3, the notices have returned with the noting addressee not found / absent. Mr. S. Chanda prays for is allowed 1 week time to obtain proper address and take 5 steps. And Mr. Brahmo, you one time.
No, Lordship.
Brahmo, for point number 1, you file affidavit.
Yes, we'll file during the course of the day.
That the affidavit be filed in the course of the day.
Lordship, in
Just
addition
after
to Lordship, we may be allowed to take Dasti also, Lordship.
Yes, Mr. Chanda, no. To take 5 steps, which is noticed by Dusty. Prayers allowed, yes.
Interim order may be extended, Lordship.
Interim order, we need to continue next day.
Hello.
Much obliged.
Lordship, in this matter, we have filed our affidavit.
Your Lordship, I'm praying for time, Sir Lordship, to file the rejoinder.
For disposal because they are making wrong submission before the trial court.
Yes.
The petitioner has absconded. He's evading arrest. His family is resisting the officials from arresting this man, and now he's filed an application. NBWA has been issued against him, Your Lordship.
So
And
where is he?
Still absconding.
He's absconding. He's
Then
not
the-
traceable.
You produce him before the court and next date.
I'm not aware
To
of
swear
this
the affidavit
fact.
personally.
Because he is not traceable. Your
I'll
Lordship,
seek
in
instruction.
spite of the
How will he file affidavit
NBWA.
This person, Great Will Sangma.
Yes.
How will he file affidavit then if you can't trace him? The
I'll
police
seek
can't trace him
instruction,
also. Yes?
It would be better if he appeared in person, Your
Let him
Lordship,
appear in
because
person.
they're resisting arrest, Your Lordship. His family
Where's
members
Ms.
are
Hazarika?
He
fighting with
is
the
not
officials.
well, Your Lordship.
And they are more than anticipated with applications.
Number 6 is whom?
Number 6, service I told. They were supposed to take
Take a
steps.
first step, Your Lordship.
What was your what was the case before this court?
That is, he wanted compensation for the medical treatment he had undergone, Your Lordship.
Oh, you were shot
Yes, by
Yes.
pangolin
while
scales.
smuggling pangolin scales.
Yes, Your Lordship. Then he absconded from there. Blank shots were fired and he was injured.
The affidavit has since been filed by the state respondent. Ms. Ipajo prays law to obtain instruction. You are absconding. You submit to file affidavit within 1 week. Yes. You don't file in 1 week, then we'll ask him to come here. Yes.
Second call. Supplementary this 5.
Yes. Which was this sudden explosion of cases against district council? You have to do a lot of firefighting. Yes.
Lord, we are challenging this impugn order dated 29/5/2026. Lord, that is at page 22, my Lord.
Which one? Yes. Page
22, my Lord. Translated copy is at page 23, my Lord.
Yes.
Lord, this order was served to us, passed on 29 on the basis of an purported complaint made by respondent number 5 on the same day, and it was served to us in the evening through WhatsApp, my Lord.
So WhatsApp?
Yes, my Lord.
No, but you got a copy. It's lecture 2.
Yes, this we have printed through WhatsApp, my Lord.
Is that accepted form of?
I don't think so, my Lord. But with all due respect to district council.
But who was the sender?
Sender, my Lord, someone from the district council, my Lord.
Then you have to have written that in petition.
Yes, we have mentioned, my Lord, that through WhatsApp.
The number of the sender, WhatsApp number.
Number is not mentioned, my Lord, but we have mentioned through WhatsApp.
You'll know the number from where the WhatsApp account is.
Yes.
But file that.
Yes, my Lord. So, my Lord, here through this order, my
How
Lord.
can you just serve by WhatsApp?
Yes, my Lord.
Who's the author of the WhatsApp account?
That we have to take instruction, my Lord.
That goes to the core of the issue also.
Because we were supposed to
How do you know it's not a prank?
my lord, this
The next time we will compose some order and send by WhatsApp and you'll come rush
because
to court.
telephonically, my lord, they call some officials, they confirm that this is order
But
from
Mr. Chandrasekhar, this is an order generated by this council.
Madam, that impugns order, madam.
Yes, you see it is.
Madam, as far as the record here is, name of the council is there.
Because now even the WhatsApp accounts are going, where they are demanding money and...
Madam, that is improper. Exactly improper.
Not improper, the service is very improper.
Exactly. That should not be. They could have delivered it personally if there is urgency.
But how can it happen by WhatsApp?
Yes, my lord. And the market, the term of the engine was supposed to expire on the 31st, my lord. Auction was supposed to happen on the next day, 30th.
You kindly supply the number of the WhatsApp number. That's
Yes,
it.
yes, my
But
lord.
it is in whose account?
I'll take instruction from my client and
I will be descending to total lawlessness then.
I'll take instruction from my client. I'll place it before this court.
You have taken it in the first instance.
Yes, my lord.
I can take instruction also. This is my duty. I didn't.
Well, let him take instruction. Who issued the WhatsApp?
Yes, my lord.
I'll obtain the instructions. This is unusual.
Well, Mr. Chandrasekhar, so this cannot be done. So
I
now you feel the same fate. One of your potential clients issued one WhatsApp, will come running to you and you have to file a case.
Yes.
And it can be a fraud order also.
Right. It's absolutely not the mode of delivery of service.
Can you expect constitutional authority to do this?
But that is yes.
The officers will place suspension. The officers by WhatsApp that you are hereby placed on suspension.
That is improper, highly improper.
Order complaint filed on same day, order passed same day, sent to us through WhatsApp. Lord. We have had instances where this particular Sardar was suspended, my lord. We moved an application. It took us around 2 to 3 weeks, my lord, for the order to be passed. But here in this case, same day it was filed, same day was passed, same day communicated by way of WhatsApp, my lord.
Disturbing that,
My lord,
yes, what is the issue?
My lord, through this order, my lord, they have restrained us from leasing this market, my lord. This market is the only source of revenue of the Darbar. Now the contention in this particular letter, my lord, is that there is a complaint that is pending before this aim as well as the police, my lord. My lord will recollect that this is an issue, my lord, wherein a complaint has been made for financial misappropriation by the Sardar, my lord. Initially, Basan suspended us. We went to the district council, got a stay of that order. Respondent number 5, my lord, who is the complainant, files a writ petition before this honorable court, and this honorable court was pleased to remand the matter to the aim and to maintain status quo, my lord. So while this matter is still pending before the same, my lord, same set of allegation, now they have come by, they have filed a complaint, respondent number 5, and the respondent district council, despite knowing very well, my lord, that this matter is before this aim, they were party in the proceedings also before this honorable court. They have passed this order, my lord. And my lord, the term of this agent has expired, my lord, and we are supposed to auction it through the funds.
No, I mean, whatever this administration or whatever hierarchy has to be maintained, you can't, the ladder of appeal. Anyway, yes, Mr. Chan, what do you have to say?
Lordship has given them 2 months time to the chief to dispose of the matter. 2 months already expired, and this complaint arise. Now the writ petitioner announced for auctioning.
Well, 2 months has arrived, but then has any action been taken by you?
No, action is supposed to be taken by the Kairim chief. Lordship remanded the matter to Kairim chief, and Kairim chief was given 2 months time to dispose of.
No matter still pending.
It is pending.
Still
2 months time already expired.
We have participated, my lord, place all our accounts.
Auctioning on 28, fixing the next after 1 day, 30. Now, because of the complaint came up that you are placing the complaint, misappropriation others, and under the market regulations, my lord.
Where's the complaint?
My lord, this complaint is not annexed here. So I've taken the instructions. They receive a notice.
Serve a copy of the complaint also to us.
That is, I admit, they receive a notice from the writ petitioner yesterday. I have obtained the instructions that to complete all the friends of this oral court. They fix the matter tomorrow for hearing of all the parties. But now they will not do it, ma'am. Because the Lordship assists of the matter, they will not do it, my lord. Lordship, give me a week's time, I'll give a short affidavit and dispose of the matter. If we go by market regulation, my lord, they have to give a notice to the council 15 days, and council officer will present for auctioning. Those are also not there.
No, whatever it is, the thing is that the court very disturbed with the manner of.
Exactly. I have no.
How can you serve?
Exactly.
And we file on the same day order.
If he denied that is issued by the office, then the matter ended. You can't do anything. It becomes a cyber crime.
Right. Exactly. Exactly.
And my lord,
Being the officer of the court, all responsibility is on the
hasty
court
manner in
first.
which the order is passed
So
also, my
proper way
lord.
of delivery of service.
The hasty manner in which the order is passed. The purported complaint is supposed to be made on 29. Order is passed on the same day, my lord.
Urgency statement.
Yes, sir. But Mr. Jeshila, the petitioner, issue notice. Mr. H. Changreso, Leonard Senior Counsel.
1 to 4.
Present with, assisted by Mr. T. Dakhar, present on behalf of the respondents 1 to 4.
1 to 4.
Author accept notice is present, so no further notice on these respondents. That notice issued to the respondent number 5 within 3 days. So the grievance the writ petitioner is that is with an impugn order dated
29/5/2026,
wherein the respondent number
number 5. No, number 3, my lord.
Respondent number who's
Three,
passed
three.
impugn order under whose hand?
3, my lord.
Respondent number 3 has page 22, right?
Yes, my lord. Page 22.
Wherein the respondent number 3 has issued orders suspending the settlement of the right nongshken of the settlement of Hatmai market right nongshken Kairems Imshin. Stop. Next paragraph, Mr. J. Shalala, counsel petitioner, submitted that the impugn order was received by the writ petitioner through a WhatsApp account on 29 May 2026. Until date, there has been no formal communication.
No, my lord, we have not
Until
received.
date, there has been no formal communication. Stop. From the respondents with regard to the impugn order. It is submitted that the impugn order is without any authority inasmuch as the impugn order, apart from being arbitrary, is without any authority, as much as the matter concerning a complaint against a petitioner is still pending consideration before the
petitioner number 2, my lord.
Before the
aim, my lord.
Before the aim of Khairem.
Writ petitioner number 2, my lord. Complaint against writ petitioner number 2.
A complaint against writ petitioner number 2 is still pending consideration before the aim of Khairem. Stop. The council has drawn attention of this court to an order dated 23/3/2026, passed WC 89/2026, where the respondent number 5, herein as writ petition number 1, had preferred the petition. What was his prayer there?
Prayer, my lord, was to set aside the stay of suspension of Sardar, my lord.
Yes, respondent number 1 had approached his court for certain orders regarding the suspension of the Sardar. So this court then had remanded Where is it in 2 months?
My lord, page number
Page
62.
62.
62.
Paragraph 7.
Yes, sir. When was the copy received? Yes, any from this court? Then no. And the respondent number 5, writ petitioner number 1 therein. Stop. This court, for disposing of the matter, had then remanded the matter to the CM Kairim for disposal of same within 2 months the date of receipt of the copy of the court's order. Stop. It is submitted that as the matter is still pending adjudication, when the matter is pending adjudication, it appears the respondent number 5 herein has lodged a fresh complaint. Before the district council authorities, to which a copy has not been served or he made aware of, and on the same day itself, the impugn order has been passed. He submits that the action of the respondents being absolutely arbitrary and discriminatory, that some internal protection be given to the writ petitioner. Mr. H. Resu, General Counsel appearing for respondent 124 in his usual fairness, has also voiced his concern about the manner in which the impugn order had been served, as much as is not proper. He, however, praised that he submits that it is correct that the matter was remanded by this court for consideration by the same Kairim on 23/3/2026, but that till date the same has not been disposed of. He prays that he be allowed to file an affidavit to bring certain facts on record. On hearing the general counsel for the parties, what strikes the court is the manner of service of the impugn order. On the in this usual fairness, boleh? Usual fairness. He, however, does not deny that the order had been passed by the respondent number 3. After that, the next paragraph. After that, next paragraph. Next paragraph. Next paragraph on hearing. The manner in how the impugn order was served upon the writ petitioner. Stop. This court fails to understand as to how this or how recourse is taken to a WhatsApp to serve the impugn order. Stop. The same is deprecated as much as deprecated, and on this ground alone, the impugn order deserves to be recalled. Stop. This is expected the constitutional authority, such as the KJDC, to function or to discharge its duties, which are of paramount importance in such a manner. Now, next, coming to the impugn order in question, as submitted by the counsel petitioner, it is seen that it is correct that the matter has been remanded to the CM of Khairin for consideration, and that the same is still pending. Stop. The perusal of the impugn order would also reflect that the same is vague, except disclosing the fact that there's been a certain complaint against the writ petitioner. It was also noted that the EM in charge Eleka is which respondent, that the respondent number 4 has fixed the matter for hearing on 3rd June 2026 at the conference hall of KCTC. Next paragraph. In view of the nature of the order, in view of the nature of service, and also nature of the order, and also taking into account the pending proceeding before the CM Khairin, in the considered view of this court, a prima facie case has been made out for interference at this stage. Accordingly, it is the impugn order dated 29 May 2026 is hereby stayed until the next date. Just after 2 weeks.
Seven, Superman.
Yes, Mr. Pasanthia.
It's an application for striking off.
Yes.
It may be allowed, my lord,
Yes.
because
Yes, application. Case 160, 2026. By this application, the who are you? The writ petitioner.
Yes, Lord.
You're a writ petitioner in WC 692.
692 of 2005.
Yes, the writ petitioner of WC 6 of the connected of the main writ petition 692 2025. You see, was striking of the name of Shri Mio MYO Swear, who has been arraigned respondent number 5. Stop. The reason for striking off is that he has since ceased to function as the Secretary of Senraj Ilakarambai and has been replaced by Sri Dao Yu Lingdo. Mr. N. Singkon appearing for the opposite parties has no objection. Opposite party number 4 has no objection. Accordingly, the name of Dao what? DAWYOO Lingdo shall be recorded in place of the earlier incumbent Mio Swear. Stop. Restrict to meet necessary correction in the cost title.
13. Daily list 13.
Mr. D,
my lord,
your problem is your representation on fructuous.
My lord, my friend has informed me that there is a notification. I will just take instruction, my lord, because without instruction, if I
This is official letter, unless it's sent by WhatsApp, no.
Line has sent for
the color says otherwise, my lord. So I will just take instruction, my lord.
Yes, Mr. M.L. Nongpur submits that the matter has since been fructuous in view of the decision by the
DSEO.
By the district school education officer for reconstitution of the school management committee of Janapriya Higher Secondary School, Bolar Bita, HOLAR with Hills. To substantiate the submission, the Learned Council has produced 2 communications dated 27/2026 attesting this fact. Mr. SDL, if I have the council petitioner, please obtain. Let's see instruction this after 1 week. Yes.
No,
meeting is scheduled on 8, Lord.
On 8, my lord. Let it be on 5th, my lord. I will take this. It is on 8, so the matter will
general
be
meeting is scheduled on 8.
8. Oh, so let it come up on 5th, my lord. My lord. Hello, bless.
Hearing 21.
This is that arbitration application, Lordship, where they have taken the issue of limitation, Lordship. Lordship, in the meantime, we have done some research, Lordship. There is a judgment by the Honorable Supreme Court, Lordship, which has otherwise dealt with these.
Old Act or new Act?
Lordship, new Act. It's a recent, Lordship. So, Lordship, I am praying if this matter can be taken on Tuesday, Lordship, we'll place the judgments and then the matter can be closed. It's in re-interplay by these.
You give a citation so I can do my own research.
Lordship. Lordship is 2024 6 SCC 1.
2026?
2024, Lordship. 6 SCC
Yes.
1. Lordship, in re-interplay between arbitration agreements under the Arbitration and Conciliation Act 1996 and the Indian Stamps Act. Lordship, in this matter, Lordship, the Honorable Supreme Court has clarified this issue, Lordship, in respect of limitation, Lordship.
Very good.
So,
Yes, Mr. S. Chanda, place some recommendation to bring on board or to place some authorities. And this is a matter up to 1 week.
22.
May I please, Your Lordship? This matter has already been heard at length, Your Lordship. And however, the state had recently filed an additional affidavit bringing on record a certain notification.
What's the matter about?
Your Lordship, Ms. T. Yangi is there in this matter. She's currently on her legs. Even the
My
assistant
lord, it is
counsel.
about the appointment of a teacher. I'm for this college, respondent 6.
Who's he, Dixon?
I'm praying if I may be allowed to withdraw this petition with liberty to file afresh, Your Lordship. Because I want to challenge a certain notification which the state have brought on record.
Yes, your objection?
No objection, Your Lordship.
Yes, Mr. Arpasanti, Council Petitioner, submits that due to the developments that have been brought on record by the
additional affidavit
filed by the state respondents, he pays allowed to withdraw his petition, will agree to file afresh. Yes.
Much
Same
obliged,
objected to matter upon its stands closed or withdrawn, our liberty has plead.
24.
Yes.
Yes, my lord.
Lordship, we have placed an application before the Darbar Shnong Ding Paso on 18/5/26.
Yes, my lord. And we met on the 27th, 5th, 2026, my lord.
What happened?
And no, my lord, we will give them. We will issue. We're going through the
Not
process,
yet
my
issued,
lord.
my lord.
We
The
have to meet
issue.
them.
The
patas, my lord.
We were seeking pata for our
See,
land
that
that
is
we were
22
settling.
4, okay. Now we already crossed May, now we're in June.
Yes, my lord.
So
They have
the
not issued
Darbar takes
us.
so long to convene.
No, my lord, we have met. We have met. They still have to get back to us. My lord, she has 6 children. She has 6 children, so she has to tell us which land will go to these children. They have to give us, my lord, this
MSOI
clarification.
Bank submits that the Darbar will settle the matter within a period of
My lord,
2 weeks.
2 weeks, my lord.
There's some urgency, my lord. If I
2 weeks, yes. Why you're cutting?
My lord, but these roads were already there since before the land again. My lord, we'll give them.
Record submissions. Mr. T. Dakhar. Oh, sorry, submitted that pursuant to the order of this court dated 22/4/2026.
My lord, these are waterways leading to the paddy fields, my lord.
Okay, the petitioners can be a picture of anything anyway. Like
If you can see the other, my lord, it's all the map, the other photographs. Yes, geotag.
My lord, we'll submit a report.
There's the
What we've
geotag,
done.
my lord, over there.
We'll submit a report, my lord.
Now all the waterways leading to the paddy fields is blocked, my lord, and
We'll
the
submit
coming
a
weeks is the
detailed
who's making the road?
Pardon, my lord?
Who's making this road?
We do not know, my lord. But we
This
know
road
there.
has always been there, my
No,
lord.
my lord,
Even
it's
before
all
the
new.
land was even.
If you can see, my lord, the first picture is
Fresh road. Anyway.
Fresh road.
The petitioners have approached the Darbar and have submitted all the necessary materials for consideration.
Yes, my lord.
MSOI Bank, Learned Counsel paying the respondent before, submits that that fact is correct. In that, and further the matter will be settled as expeditiously as possible.
Yes, my lord.
Within
We'll
a period
submit a report
within
also,
a
my lord.
2 weeks, within a period of 2 weeks from today. So, Mr. Edakhar has also produced for the court certain photographs showing I won't require any.
But my lord, if I may, the materials, my lord, I don't have instructions that we receive materials.
Yes, at least after 2 weeks. On a fixed item.
25.
He takes pictures back.
My lord, as per the order dated 6/3/2026, lordship.
Your Lordship, they would to produce the
I was
master
asked
roll
to-
register.
Not produced. I was asked to inquire whether they are maintaining any register of casuals. 6/3/2026, lordship.
Yes.
Now, my lord, my instruction.
Does the register exist?
They are not maintaining the register of casual workers. They are making only the.
That's my only proof
This
of
is the
employment, Your Lordship.
advice slip, lordship. They are maintaining this one, lordship.
Now, how do you pay them?
My
Without
lord,
the register?
from 2025 onwards, they are maintaining, lordship.
How is it possible? And how do you pay them then?
Prior to that, they are not maintaining the.
What does say?
He's a
Right?
casual worker, lordship.
Same thing.
Casual worker, lordship.
This ordinary, formal appointment letters, Your Lordship, in this
There
regards
is
to
no
master roll.
formal order of appointment and there is no formal order of disengagement or the termination, lordship.
Then does the register they ever work?
No, lordship. Now they from 2020-25 onwards, lordship, they are maintaining, lordship.
So how can he substantiate the fact he works as a casual worker then? You don't have record appointment, don't have record of his work.
My lord.
That means anybody can come and say that
My
I
lord, because
worked under Mr. Sheikh for 10 years.
His appointment was given in lieu of the land. Now the petitioner has separated from the.
He's a person.
Yes,
your
yes.
mother-in-law's land.
From the donor of the.
It's all based on private request by the
So now
landowner.
My affidavit that in place of the petitioner, his petitioner's son was.
Not the petitioner's son, the landowner's grandson. He's not my son, Your Lordship.
Your nephew-in-law.
I don't know, Your Lordship. Yes.
Yeah, if you're a son-in-law of the landowner.
So the landowner write a letter to the department saying that since he has separated from my daughter,
Still her daughter. And so as
kindly
punishment, take the job with
kindly
you.
appoint my grandson.
Yes.
After 12 years of my continuous service, Your Lordship.
So that's the punishment you have to face.
My lord, nothing survived deciding this writ petition, lordship.
Your Lordship,
He wants to be paid for the period that he worked.
No, my lord, that is.
Yes, Lordship, and also the conferment of RCW. Because he has a legitimate expectation, Lordship.
There is no confirmation, lordship, because he is
There's a scheme, Lordship.
casual worker, and he is no longer in the service.
What's he doing now?
He's unemployed, Lordship.
How old is he?
He's about 40 now.
Still young, man.
But Lordship, this Meghalaya RCW scheme squarely covers my case, Lordship.
How can he be regularized? How can he begin RCW in a post which is occupied by someone else now?
Yes, Lordship. The scheme itself prohibits.
Where's the termination of your casual employment?
There's no termination. I was orally informed, Lordship.
See, the thing is that Mr. Masangria, you have to show that everything stems from your appointment, right?
Yes, Lordship.
Any rights that
Yes, Lordship, they had
that
to
you seek
maintain.
derive, or what rights are vested in you derive from your appointment letter.
Yes, Lordship.
And so, and what goes on down the years. But that is the fountainhead of what claim you might have.
Lordship.
Correct?
Lordship.
And so you don't have appointment letter, you're appointed just like that. There's no record of your working. That's why this court, in consideration of the service you see you rendered, had asked them to produce the register of how long you've worked. Then that at least will testify to the fact that you have worked for how number of years or something. That's not there.
Master rules are
There's no appointment, there's no termination, there's no register of you working.
Yes, Lordship.
What to case like this? It's beyond the scope of law. The only the factum of payment is this bank account.
Yes, Lordship. I've been receiving my salary since 2013, Your Lordship. Till February, when I went to inquire regarding non-receipt of my salary from 2025, January.
You've been receiving?
Yes, Lordship. And for the month of February, I went to inquire regarding non-receipt, and that was when I was orally informed that I was terminated from my service. And that I was
party.
No, Your Lordship. I was not aware regarding all these, Lordship. It was only brought on record by way of affidavit.
Neither the mother-in-law was made a party, nor the person who has been...
Not a person who's taken your job.
Yes.
Yes, Lordship. I'm not claiming relief from any of them, Lordship. It's just,
but he's taken your job.
Lordship, just the arbitrary termination of my appointment, Lordship.
Yeah, you casual or muster role?
Muster role, Lordship.
She's the landowner.
Landowner, mother-in-law.
I think Mr. Lasonglia, this matter can't be settled just like that. Have you got an affidavit?
Yes, Lordship, I have.
The affidavit.
My Lord will kindly see para 6. Para 6, 7 and 8. It is the letter issued by the landowner.
There's no appointment. That's the whole problem. Is otherwise, some of your rights would have been protected.
My Lord will see that annexure. That is the letter written by the mother-in-law.
Then this has become incompetent petition.
Lordship.
What are you going to do?
Kindly grant me some time, Lordship. I'll seek instructions.
Otherwise, see in the affidavit that they have to pray for a removal also. See. Yes, sir. It's about 2 weeks to enable the pressure of pre-instruction. Otherwise, it's incompetent. It have to be dismissed. You can file afresh if you want. But you have to make your mother-in-law and your nephew-in-law parties.
Yes, Lordship.
26.
Lordship.
May I please, Lordship? Lordship, I have filed my rejoinder, but regards to the affidavit in reply to the private respondent 9, due to some inadvertent errors, it was not be able to process, Your Lordship. So I pray that the matter may come after 2 weeks, and
yes,
I'll file at the earliest days.
We've already filed our affidavit.
No, this is by whom? This one today.
We filed rejoinder.
In reply 1, 6 and 8.
To the District Council. Affidavit.
Rejoinder?
Lordship.
I have received a rejoinder today.
Filed by them?
Filed by them.
Lordship.
Yes, if someone submits the rejoinder, just filed by the petitioner. Yalong Village.
Lordship.
I just received today. Stuff. Next one, MSN Lamari prays that he allowed some more time to file rejoinder to after filed by respondent number 9. Stuff. Prays all this after 2 weeks. Yes.
Lordship.
28.
My Lord, this is the matter where the permissions were not granted. My Lord, during the intervening date, previous day...
Delay. Argue on delay.
My Lord, there has been a new development. We have filed an application for extension of the lease since it was expiring on the 30th of June. And my Lord, what we have learnt is that they are extending the lease for the other people. So since we have filed an application, I may be allowed to bring it on board by an affidavit.
Mahanta?
Lordship, he went to hospital. He has some difficulties.
My lord, we have informed some Mahanta also.
Please matter after 1 week.
My lord, we may be allowed to bring that application on board.
Certain developments with regard to renewal of the lease of the petitioners.
My lord, may we be allowed to file an affidavit to bring that
Of course,
application?
bring on record. You can bring on record by affidavit.
32.
Obliged, my lord.
32.
May I please your lordship? Lordship, one petitioner, my lord, has passed away, my lord, on 1st of May.
In this 519?
My lord, yeah, my lord.
No, there are 4 writ petitions, my lord.
Petitions,
The third,
my lord.
the third
The
petitioner,
third one,
my
my
lord.
lord.
WPC 521.
My lord. My lord, I may be allowed to file substitution application, my lord.
521. In WC 521. Mr. SK Hassan, the council petition submits that the writ petitioner.
Yes, my lord. Writ petition.
Expired on?
On 1st of May.
On 01/05/2026.
Yes, my lord.
He prays funds allowed to file a appropriate substitution
my lord.
Bring the record
My lord, legal heirs.
the legal heir stuff. As these other matters connected to the
Other 3 matters, my lord.
namely 519,
Yes, my
520,
lord.
and
522.
522, my lord.
These matters after 2 weeks.
My lord. Highly obliged.
36. 36.
Yeah, Lordship, this is a very small issue here. There has been a delay in releasing the pension, Lordship. It was almost after 8 years of the retirement of the deceased, Lordship. The pension has been
8 years?
Yes, 8 years.
If you didn't file agenda?
My lord, no. My lord, this is only on law, Lordship.
He is claiming interest on the delayed payment of pension.
What he is admitted in his counter affidavit saying that there is an administrative lapses, Lordship. So that administrative lapses cannot be a ground to deny.
When were you paid a pension? When did you retire?
Lordship, he retired on 28 February 2017.
28/02/2017.
Yes,
When
then
was
the
the first
pension was released November 2024, Lordship.
November
2024.
2024. That means after 7 years.
7 years and almost 8 months. 8-9 months.
You're serving as?
He's a pump operator, Lordship.
Pump operator?
Yes, operator. PSC department. Now, in the affidavit, they have clearly admitted that it was an administrative lapses, Lordship. I'll just rely the affidavit of the.
So, as of lapses, it has to be that burden has to be borne by the officer concerned.
Yeah, my lord will see.
It has to be with that your entrance has to be
Para 11. Para 11.
Yes.
Para 9 is the details when the pension was released, and para 11, Lordship. That with regard to the abatement made in para 8, 9, 10 of the writ petition, the answering respondent submits the delay in processing and payment of the family pension and service benefit was not intentional, but due to the certain.
That means after 6 years after retired, the pension papers were sent from Ampati.
Lordship. Now
who's the person concerned in Ampati?
My lord, there is a rule in the pension rules as well as the FR rules which says that prior to 2 years of the date of the retirement, the pension should be, the paper should be processed.
2 years or 6 months?
2 years, Lordship. 2 years, Lordship.
So,
61 of the.
Who was the executive engineer in charge in 2017? You find it out, we'll pass orders that what is officers responsible didn't send the pension papers.
My lord, what
they'll have to be deducted from their pension also.
My lord, if there is an order like this, my lord, they will deduct from the person who were
who was responsible.
Yes, Lordship. Lordship.
Yes.
Lordship. Department can recover from the person.
But he has to be on board.
My lord, it would be very
Find
difficult
out.
because now the person
You
comes
can
up.
find out. They are all government servants.
Yes.
Over their point of time. See, in affidavit, they've said that it is submitted that, okay, the pension papers forwarded on by 2/5/23 and received on 9/5. Then on scrutiny of the payment papers so and so. So they processed it.
They have given a long list.
No, long list.
But that cannot be. That cannot substitute.
Yes, Mr.
The records, Lordship, it was carried back and forth, Lordship, due to some
Mr. Karmi,
lapses.
The thing is that, see, only one, the lapse is what? The lapse is in the initial time from 17 to 2/5/23. That is the only lapse. We're looking at 5 years. There'll be interest on 5 years in the pension delay.
My lord, law.
From the time it was processed, that you will not be entitled to any
My
pension.
lord, as per the law, the 2 years.
Doesn't matter.
Then from the date of retirement
Doesn't
till the
matter.
date.
This is we're going to inflict
Pay-
punishment on the officer's
Lordship, at
concern.
page 6 of my affidavit, I have given this statement, Lordship,
Yes.
with regard the events. Statement of the events. Page 6. On 30th 9/2016, submission of IPS for approval.
Okay.
And thereafter on 3rd March 2017, resubmission.
No, he died.
He died 2018, Lordship. Road
He
accident.
died on
2000,
Died on February
2018.
Yes.
2018.
And he
17, right.
died on
2018.
18, Lordship. Road accident, Lordship. 17/11/2018.
What is affidavit intention to get married? What affidavit is this?
My lord, these were the document placed before the respondents. They have given the list that these are the documents were produced before the official respondents.
Lordship, if I may read paragraph 11 of my affidavit, Lordship. Paragraph 11 of my affidavit. With regard to the amendment made at paragraph 8, 9, 10 of the writ petition, the answering respondent submit that the delay in processing the payment of the family pension and service benefits was not intentionally but due to the certain procedural and administrative lapses. It is submitted that late PC Das, ex-pump operator, retired on 28/2/2017. The pension papers were forwarded from Ampati Division PHE by letter dated 2/5/2023 and received in the office of the respondent number 3 on 9/5/2023. On scrutiny of the pension papers, the service book part 1 and 2 and other pension papers were returned to the executive engineer PHE Ampati Division by letter dated 30th/5/2023 with a request to resubmit the same along with form 3 and form 4. The service book part 1 and part 2 and other pension papers were resubmitted by the office of the executive engineer PHE Ampati Division, Ampati by letter dated 4/8/2023. However, on further scrutiny of the pension papers, the same was returned to the office of the executive engineer PHE Ampati Division by letter dated 25/8/2023, directing the concerned office for necessary correction as the name of the late government servant as shown in the service book and other documents were not the same. That is, in the service book part 2 and part 3 and the death certificate, it is written as Prafulla C.H. Das, whereas in all the pension papers the name was written as Prafulla Das, and the LPC from Treasury Office was not obtained. In response to the above, the executive engineer PHE Ampati Division by letter dated 7/12/2023 had submitted the corrected pension papers, but the officiating pay in the LPC issued by the Treasury officer was 15,020 rupees, which is under the old pay scale. In order to avoid further delay, the dealing assistant had called the head assistant of the office of the executive engineer PHE Ampati Division to request the Treasury officer Tura to issue a revised LPC as on the 28th February 2017 as fixed under the 5th Pay Commission. Upon receiving the LPC from the Treasury Officer by letter dated 09/09/2024, the Office of Respondent number 3, by Office Order dated 12/9/2024, had sanctioned the leave encashment of 5,22,000 only to the petitioner and forwarded all the pension papers and other necessary documents to the Office of the Accountant General, Meghalaya, by letter dated 12/9/2024. The pension case of LPC of late LPC Das has been settled by the Office of the Accountant General by letter dated 7/10/2024. So all these lapses occurred, Lordship. So that's why the delay happened. And finally, it was settled by the AG office and released to the petitioner. This is the situation, Lordship.
What of the DCRG?
DCRG also same time, Lordship.
How much?
DCRG about 5 lakhs, Lordship.
Leave encashment 5 lakhs. DCRG 5 lakhs. What is your family pension you're getting now?
Family pension, Lordship, most probably above 20, Lordship.
Other Tamil benefits?
Gratuity, leave salary, and that
all included.
All they got, all she got in the month of that too. Also, when I approached to the Honorable Court, Lordship.
Other benefits they have received, except family pension.
My lord is right that Rule 56 says, if I read, Lordship, preparation of list of government servants due for retirement. Every head of the department shall have a list prepared every 6 months. That is on the 1st January and the 1st July each year of all gazetted and non-gazetted government servants who are due to retire within the next 20 to 30 months.
Now, what do you say 2 years?
2 years, Lordship, here, Lordship. Preparation of pension payment, that is Rule 61. That says that prior to 2 years. And there is a judgment. In that judgment also, Lordship, I'll just first realize that AIR, I have given the list of books, Lordship. AIR 1985, Supreme Court 356.
And order delay is there, whatever it is.
My lord, para 1 and 2, this is a very landmark judgment, and this judgment has been cited by Supreme Court as well as different High Courts, Lordship. Lordship, I'll just read para 1. Pension and gratuity are no longer any bounty to be distributed by the government to its employees on their retirement, but have become, under the decision of this court, valuable rights and property in their hands, and any culpable delay in settlement and disbursement thereof must be visited with the penalty of payment of interest at the current market rate till actual payment.
Now, we have to get a chart that has been given by him, whether the service book is complete or see, first one, you submitted for approval.
Another judgment also says that the rule provides, and if it has to be done within a period of 2 years by interpreting the rules.
So you minus 2 years from this 7 years, 5 years will be entitled to interest.
No, my lord, law judgment says from the date of retirement, Lordship.
2 months.
2 years, Lordship. I'll just rely one more judgment, Lordship. That
unapproved. Why was this unapproved, this initial pay statement? See in the page 7, Mr. Karmi. Unapproved IPS subsidiary. Unapproved again and up to 18. Then grant an increment for the period 93 to 94 to 95, 96 to 97, 2017. Then service book submitted again on 2/11/2018. Initial pay approval for so. He died. Okay. in 1811.
2017.
Now regarding succession certificate, okay, that period has to be taken away. What is the application? What is this at page 8 at column application for financial upgradation? That means all along now he was entitled for ECP, then he got MECP also posthumously. What to do, Mr. Sheikh? Because you had too many, you know, that what you call benefits that were still due, like increments, which they factored in after he died.
Yes.
Number one. Number two, then succession certificate came away because he died. Then after that, up to 2020, then the
my lord, with regard to succession certificate, my lord.
Then 21 financial upgradation. Then 22 grant of first, second is ECP. Then 15.3 grant of first, second, right? And then submission of service books again for approval. Then grant of MSCPS. Then that was 14.10.22. Then finally the pension paper was forwarded for, you know, you had to calibrate the entire amounts that were due to calculate what was your terminal benefit. That is why.
All they ought to have done, Lordship.
During his
service.
Right.
My lord, I'll just quickly one judgment, Lordship. I'll not burden my lord with many judgments, although I have 4 or 5 judgments. That 1999 Supreme Court 1212. Here in this judgment, there is a delay less than 3 years, Lordship. Paragraph 5 and 6, Lordship. Here they have interpreted the rules, Lordship. We have referred in sufficient details to the rules and instruction which prescribe the time schedule for the various steps to be taken in regard to the payment of pension and other retired benefits. Thus, we have done to remind the various departments.
So what is the total emolument? Like final pension is how much you're getting? 20,000?
More than 20,000, Lordship.
What's the exact amount?
Exact amount I have to ask.
You get the figure?
Yes.
We might give you notional
And Lordship, if I may just point out this at paragraph 12 also, Lordship, of my affidavit, paragraph 12.
1, 2, 3, 4, I'll take it.
Last 6 lines, Lordship. Paragraph 12, last 6 lines. Just point out here, the delay. Paragraph 12.
Yes.
Last 6 lines. The undue delay in submission of the pension papers may be largely attributed to the fact that
that's what we're seeing.
Incumbent his pay had to be regularized since 1993, and the approval was sought.
So that is why we're seeing that ECP and MSCP.
Yes, yeah, all the
payments, the leave encashment. No, leave out, no, I mean the other ones.
Yes.
Yes. These are tweaks enable Mr. S.A. Sheikh to cut at length, cut at some length. Little tweaks enable Mr. S.A. Sheikh to apprise the court the exact amount drawn. The first amount you drew after you retired, when you get all the acknowledgements, that is in November 2024. Yes. Madam.
I'm going up.